They didn't come on
4 weeks.
4 weeks. देखिए कोई पर्सनल रीजन दिया
नहीं हमको बताएं कि मिस्टर त्रिपाठी के पिताजी सीरियसली ये लोग चेन्नई गए ट्रीटमेंट कराने के लिए.
Second appeal number 75 of 2003. Counsel for the appellant is present. Nobody appears on behalf of the respondents. However, an adjournment request has been circulated, and the counsel for the appellant has also been intimated that the respondents would seek adjournment. As per the request of adjournment, the arguing counsel, Mr. DT.17.09.2025, is unable to attend the court on account of his personal difficulty, and a prayer has been made for adjourning the case for 4 weeks. The records reveal that the argument of the case has commenced on 10th of September 2025, and the matter was posted today for further hearing to be taken up as first case at take. However, on account of personal ground of the arguing counsel, the matter is adjourned and is directed to be posted on 15th of October.
15.
The matter being, the hearing having already commenced, it is expected that the respondents would cooperate in the matter of further hearing process. I think another bench. All considered. All considered.
Item 16, second appeal 538 of 2016.
किसकी तरफ से एडजर्नमेंट रिक्वेस्ट आया है और कितने दिन का एडजर्नमेंट? How many days? Only for today. AC number 538 of 2016. A request for adjournment has been made on behalf of the counsel for the appellant, namely Mr. B. Kumar, on personal grounds. The second appeal is of 2016, and no substantial question of law has been framed so far. However, on account of personal reasons of the counsel for the appellant, was dismissed on express.
Item 21, second appeal 502 of 2017.
So, from personal reasons. essay number 502 of 2017. Advance notice seeking adjournment has been circulated. With a prayer to adjourn the matter for 2 weeks on personal grounds. The second appeal is October 2017 and no substantial question of law has been framed so far. However, on account of personal grounds of appellant, the matter is adjourned and is directed to be posted on 6th of October.
Item 1 for final disposal, second appeal 588 of 2004.
Lord, in this case, my lord, I have not gone through the LCR.
We don't bother about
2 weeks time.
it. No, we will not grant it. If you have not gone through the NCR, that's your problem.
So this is a plaintiff second appeal.
Just a
Again.
moment. Just a moment. With consent, we have posted this case today. The last adjournment was on 10/9/2025. What have you done for the 1 week? Yes. What steps have you taken to go through the records?
Lord, I have not gone through the LCR.
This is a plaintiff second appeal against the judgment of reversal. May kindly see order
Just a
number.
moment. Suit was decreed.
Suit was decreed against which the defendant filed
Appeal allowed.
appeal
Who
allowed.
filed the appeal? All the defendants?
Appeal was filed. Defendant number 1, Lakshmeshwar Pandey.
Defendant number 1 to 3.
Defendant number
1 to 3.
1 to 3.
Ji.
Yes, what is the substantial question of this?
Order number 4, Lords.
Yes.
Whether the judgment of lower appellate court reversing the finding of the trial court on the ground that the family settlement having been entered into in the year 1980 after death of Bhutta Devi cannot be given effect to.
Give me the bird's eye view of the case of the respective
Yes.
parties.
Para 3 Lordship of the learned appellate court judgment, Lords.
Yes.
Page 2, Lords.
Yes. Yes, I'm there.
Yes. The case of the plaintiff in brief as plaintiff is that the gesture of the parties possessed property in nowadays
एकदम detail में पढ़ना.
Jil. I'm sorry. Nowadays PS Chaki district so and so Padlibare village Manikpur PS Jasidi district Devgar Pyaru Pandey was the common ancestor.
Wherever you think that there is a dispute, you should tell us. This is an admitted fact.
Admitted fact.
So wherever you say that there is a dispute, you pause and tell me that this is the point where
Yes, definitely I will follow.
Yes. Common ancestor.
Yes, Peru Pandey was the common ancestor of the party. He had 2 sons, Horil Pandey and Bechu Pandey. On the death of Peru Pandey, Horil Pandey bought the lands of Manikpur, Jasidi in partition, and Bechu Pandey bought the land of Navadi, Silferi, and they came in possession of Saint. Horil Pandey had one son, Choa Pandey, and Choa Pandey had two sons, Sri Ram Pandey and Durga. गलत लिखा, देगा की जगह दुर्गा होना चाहिए, दुर्गा पांडे. Durga Pandey. Sri Ram Pandey died issueless. Durga Pandey had one son, Kinu Pandey, husband of the Bhuka Devi. यहाँ भिका लिखा हो जबकि एक्चुअली भूखा होना चाहिए. Bhuka Devi. Recorded deal.
पंकज जी, okay.
In the last Ganges survey settlement, the Manikpur property stood recorded in the name of Bhuka Devi, wife of Kinu Pandey. Since they died as Jambabandi number 67, the property of Navadi, Silferi, recorded in the name of Bhiko Pandey. The subject matter of suit lands of Manikpur recorded as Jambabandi number 67. The details of lands are given in A schedule of the plan. Kinu Pandey died leaving behind his wife Bhuka Devi, who was further nursing lady. She was unable to manage the suit land. Bhuka Devi requested the Bhubaneswar Pandey, the father of the Bageshwar Pandey, for assistance and management of the suit land. The Bhubaneswar Pandey came to village Manikpur and resided in the house of Bhuka Devi, and he started possessing and cultivating the suit property. Bhubaneswar Pandey was reversioner of late Kinu Pandey. After death of Bhuka Devi, Bhubaneswar Pandey came in exclusive possession. And
How is he reversioner of late Kinu Pandey?
because he looked after the landlordship. And
तो reversioner कैसे बन जाएंगे?
it has been mentioned in the plain reversioner's lordship. He
That
possessed
is not correct. Merely
the,
because
it
he
is
is in
a correct
possession.
because the rent receipts was being
No,
issued
whatever be the issue.
in the name of Bhubaneswar
Whatever
Pandey
it is.
and the Bhuka Devi
Who is
lordship.
the reversioner?
The Bhubaneswar Pandey
So what is
lordship.
the concept of reversioner?
Because he cultivated the land, look after the landlordship
That is not the concept of reversioner.
on the request.
He is not a, otherwise he is not a family member.
Family member. He is the dever of the Bhuka Devi.
Bhuka Devi,
के देवर हुए भुवनेश्वर पांडे.
Bhubaneswar Pandey. Father बागेश्वर पांडे. इसमें तो ऊपर बागेश्वर पांडे का कहीं कोई नाम नहीं आया है.
बागेश्वर है बता दो.
बताइए. अभी जो पूरे genealogy में there is no mention of बागेश्वर पांडे.
Yes. हम genealogy बता दें. भुवनेश्वर पांडे के दो बेटा हैं, महेश्वर पांडे.
भुवनेश्वर नहीं, भुवनेश्वर तक का genealogy बताइए.
हाँ, भुवनेश्वर के ही बता रहे हैं. तो भुवनेश्वर जो है, बिच्छू पांडे, they are two brother lordship, Horil Pandey and Bechu Pandey. The Bechu Pandey died leaving behind Bhiko Pandey.
Yes.
And Bhiko Pandey died Shivlal Pandey.
Okay, Shivlal Pandey.
And Shivlal Pandey died Bhubaneswar Pandey.
But that is not the genealogy mentioned in the plaint.
This is my genealogy, lordship.
We have to see you are the plaintiff.
I
We
am
have
the
to see the genealogy as disclosed in the plaint, right?
But it has been mentioned, lordship.
Where it is mentioned? Show me. Dikhai plaint dikhai.
प्लेट में पारा 3 में दिया हुआ है, पारा 1 में लॉस की रिलेशनशिप. पारा 3 में बेचू पांडे, भिकू पांडे, शिवलाल पांडे एंड भुवनेश्वर पांडे. पारा 1 में पेज 3 में दिया हुआ लॉस.
So the genealogy which is recorded in para 3 is not correct.
According to us, it is a correct, and according to defendants, it is not correct, lords.
अभी जो para 3 में आप genealogy जितना भी देख रहे हैं, उसमें ये भुवनेश्वर पांडे का तो कोई नाम ही नहीं है.
नहीं, प्लेंट में तो दिया हुआ.
प्लेन में दिया हुआ है, लेकिन para 3 of the appellate court
हाँ,
judgment में
appellate
नहीं
court
है.
में नहीं है, लॉर्ड्स. करेक्ट.
नहीं है ना?
हाँ, appellate court में नहीं है. सही, लॉर्डशिप सही बोल रहे हैं.
ठीक. According to you, Bhubaneswar Pandey is the devar.
देवर ऑफ भूखा देवी.
Continue.
Yes. subject matter of this suit lands of Manikpur recorded as Jamamandi number 67.
नीचे हटेगा
अच्छा,
for
नीचे।
assistance in management of the suit.
So, the Bhuneshwar Pandey was the reversioner of the late Kinu Pandey. After death of Bhukha Devi, Bhuneshwar Pandey came in exclusive possession and control of the suit property. On the demise of the Bhuneshwar Pandey, the plaintiff number 1, Bageshwar Pandey, and defendant number 4, Maheshwar Pandey have continued to jointly possess, and after death of Bhukha Pandey, they paid the rent of the suit property. Manikpur Mauja was under the Rohini estate, and upon its vesting in the state of Bihar, the Rohini Ghatwal estate filed return showing the Bhuneshwar Pandey and Bhukha Devi as a tenant of Jamamandi number 67 of Mauja Manikpur. Bhuneshwar Pandey was in exclusive possession of the suit lands against the interest of Bhukha Devi. All the relevant documents in regard to the suit property stand in the name of Bhuneshwar Pandey. Suit property are recorded in the name of Bhukha Devi and Bhuneshwar Pandey, even in registered two lawsuits. Thus, the plaintiff along with the Maheshwar Pandey have a right, title and interest over the suit property. With the change in law, after coming into force of Hindu Succession Act, Bhukha Pandey took Dakshineshwar Pandey by
The
wrong.
plaintiff is son of Bhukha Pandey, Bageshwar Pandey.
Bhuneshwar Pandey. They are
Plaintiff is Bhuvneshwar Pandey.
Bhuneshwar Pandey. And defendant is Dakshineshwar Pandey.
No, plaintiff number 1 is Bageshwar Pandey.
He is the son of the Bageshwar
That's
Pandey.
right. Plaintiff number 1 is Bageshwar Pandey.
Bageshwar Pandey, correct.
And Bhuvneshwar Pandey is also co-plaintiff? No.
No,
He must have
he
expired
died.
by.
Subsequently, he died, Lord.
His son is claiming.
His son is claiming on the basis of family settlement executed in the year 1980. I am coming, Lord.
Yes.
Thus, the plaintiff along with the Maheshwar Pandey have a right, title, interest over the suit property. With the change in law after coming in force of the Hindu Succession Act 1957, Bhukha Devi took Dakshineshwar Pandey by wrong advice given by the
Who is Dakshineshwar Pandey?
defendant. Lord.
How is he related? Is he related or he is the third person?
No, he is the relative, Lord.
Relative, what relation?
Relation has not been mentioned, but he is the relative. गोदिया लिखा हुआ है. He is the relative. The Bhukha Devi adopted Dakshineshwar Pandey, Lord, by virtue of registered deed of adoption, Lord. Coming in the force of the Hindu Succession Act of 1956, Bhukha Devi took Dakshineshwar Pandey by wrong advice given by the lawyer in order to safeguard their title in the suit property. On 28/7/1964, Maheshwar Pandey, his wife, Srimati Lalan Mohan Devi, gave their son Dakshineshwar Pandey, defendant of adoption to Bhukha Devi. On 22/9/64, the said adoption deed number 200 was registered. In title suit number 4165, a posted adoption deed was challenged by the Gotia of the parties, which was dismissed on 29/6/1968, and said adoption of Dakshineshwar Pandey was upheld. Further case of the plaintiff is that thereafter dispute arose in the family. The plaintiff Bageshwar and defendant number 4 Maheshwar Pandey decided to enter into family arrangement. According to family arrangement, defendant number 1 Dakshineshwar Pandey bought 6 acres 4 decimal and plaintiff Bageshwar Pandey and defendant Maheshwar Pandey bought 13 acres 93 decimal out of the suit property. Under the said arrangement, the house bearing number 595 and tank plot number 548 were kept joint among them. On
Just a moment. When this particular person, Dakshineshwar Pandey, who is the son of Maheshwar Pandey, right, was given by way of adoption, then under what circumstances any portion of the property could have been given to Dakshineshwar Pandey?
After death
In the
of
family settlement.
after death of Bhukha, the Dakshineshwar Pandey inherited the property of the Bhukha Devi, Lord.
Dakshineshwar, this family arrangement is between defendant number 1 Dakshineshwar Pandey and the plaintiff Bageshwar Pandey.
Bageshwar Pandey. Bageshwar Pandey is the son of Bhuneshwar Pandey, Lord.
Okay, Bageshwar and the defendant Maheshwar Pandey.
Maheshwar, yes. Yes, correct.
Maheshwar Pandey is the father of Dakshineshwar
Dakshineshwar
Pandey,
Pandey.
and Maheshwar Pandey has already given his son by way of adoption.
Adoption.
So how Maheshwar Pandey will form a part of joint family with Dakshineshwar Pandey?
But it is true that property was also given to the Maheshwar Pandey according to family arrangement deed laws. Exhibit 5.
Yes.
Exhibit 5 laws.
Yes, continue.
The plaintiff, according to family arrangement, defendant number 1, Dakshineshwar Pandey got 6 acres for dismissal, and the plaintiff Bageshwar Pandey defendant Maheshwar Pandey got jointly 13 acres 93 decimal of shoreline property. Under the said arrangement, the house bearing number shown is kept joint in one name. On 5/10/1980, said family arrangement was registered as a deed of settlement number 3328 of 1980, details of which is given in Schedule B of the plan. Accordingly, parties came in possession of their respective share and parties paid rent as per the said family arrangement. Sometime after said family arrangement, Dakshineshwar Pandey, in conclusion with his father, Maheshwar Pandey, defendant number 4, got mutated the entire suit property in his name in the year 1992 in revenue miscellaneous case number so and so in the court of DCLR, Devghar, in which the DCLR passed an order 24/1/1993 directing for deleting the name of the Bhuneshwar Pandey, the father of the plaintiff, from the registered to. Bhuneshwar Pandey filed an appeal in the court of DC Devghar against that order by his order dated 22/4/1993. DC Devghar confirmed the order of the DCLR Devghar. The order passed by the revenue authority to remove the name of the Bhuneshwar Pandey from registered to does not create any right, title and interest in favor of the Dakshineshwar Pandey. The said order of the DCLR Devghar and DC Devghar are void and not binding on the plaintiff. Bhuneshwar Pandey already acquired prescriptive title in the suit property long before coming in the course of Bihar Act 1949 by remaining and continuing in exclusive possession of the suit property for a period over 12 years, adverse to the interest to the express knowledge of the Bhukha Devi. Dakshineshwar Pandey got nothing to inherit by virtue of said resolution, as the suit property has already been acquired by said Bhuneshwar Pandey, Dakshineshwar Pandey. The defendant number 1, nothing on the demise of the Bhukha Devi. All the property are bound to implement the family arrangement dated 5/12/1980. The plaintiff is entitled to partition on the basis of above facts. Order of the DCLR and DC Devghar are void and baseless. The cause of action suit arose on 22/4/19 when the Deputy Commissioner Devghar dismissed the appeal and confirmed the order dated 27/1993. Hence, the plaintiff brought the proposal. The defendant in substance, the defendant appellant contested the suit by filing written statement. Other defendants have not contested the suit. The case of the defendant appellant, as per the written statement, genealogy table filed by the plaintiff respondent is false and denied by the defendant. Hari Pandey and Bechu Pandey were not the descendants from the common ancestor, and they were the different branches. Genealogy table of Gaur Pandey and Horil Pandey given by the defendant appellant has been confirmed in title suit number 41 of 1965. जो एडवर्समेंट हम लोग चैलेंज किए थे वो डिसमिस हुआ था, उसी का टाइटल सूट नंबर 41 1965 अवेलेबल है. So plaintiff respondent cannot challenge the same with the present suit. His other case is that ancestor of Bhukha, they had no any concern of nowadays Silkari PS Chakai, now Chandra Mandi. Similarly, the ancestor of the plaintiff had no concern with the property of Maja Manikpur, Jasidi. Horil Pandey and Bechu Pandey were the different branches, therefore partition of the property between the Horil Pandey and Bechu Pandey did not arise. Bhukha Devi, wife of Kindu Pandey, was recorded in it. Kindu Pandey died long before the next person settlement, leaving behind one son, Babulal Pandey, and widow Bhukha Devi. During the next person settlement, said Babulal Pandey was recorded as the sole owner of the Jagomati number 30. After death of said Babulal Pandey, his mother Bhukha Devi was as his legal heirs and successor. As such, she became the exclusive owner of the lands of Mother Manikpur. Bhukha Devi used to manage the property and landowner, so she was not the Nasim lady, and villagers never tried to take away the property of the Bhukha Devi. She never requested the Bhuneshwar Pandey, father of the plaintiff, one respondent, help to her in cultivation and other affairs or for his welfare. Bhuneshwar Pandey was a poor man. Bhukha Devi kept him for performing puja part in her Thakur body. it is also false to say that Bhuneshwar Pandey started possessing and cultivating this property and maintained Bhukha Devi being the absolute owner of the property. She used to feed Bhuneshwar Pandey. It is false to say that Bhuneshwar Pandey was a reversionist of the Kiru Pandey. Bhukha Pandey died in the year 1965, leaving behind her a Dr. Dakshineshwar Pandey, dependent appellant.
The entire genealogy is under dispute.
Genealogy dispute. The main case of the plaintiff is that registered family arrangement lawsuit. That Dakshineshwar Pandey put his signature lawsuit, and nobody was challenged the registered family arrangement lawsuit. Nobody was challenged. Meaning they are like the family arrangement is executed by the Dakshineshwar Pandey and other person. They have attained his final lawsuit.
And what about the adoption?
I am not disputing the adoption.
No, you are the plaintiff, right?
I am the plaintiff.
You have said that under wrong advice.
Maybe wrong advice, but it is a registered sale lawsuit.
Registered
This is registered sale, and that registered sale was challenged in title suit lawsuit, which was also dismissed. Which was also.
So there is no scope to challenge that.
There is no scope of challenge, but and so far the family arrangement deed is concerned lawsuit. It is a registered document. All the parties have put their signature in the family arrangement lawsuit.
So, who are the signatories to the family arrangement of the 1980, which is the bone of the
Yes.
Who are the parties to the family arrangement?
This is a type copy of the Exhibit 5 laws. Family arrangement laws. Dakshineshwar Pandey, Maheshwar Pandey.
Just a moment. Dakshineshwar Pandey.
He is the adopted son laws of the Bhukha Devi laws.
Just a moment. Adopted son
Of Bhukha Devi.
Kinu Pandey.
Yes.
Kinu Pandey was the husband.
Husband of the Bhukha Devi.
But Posh Pita to nahi because she adopted him after the death
After the death of the
her husband.
yes.
Adopted son of Bhukha Devi.
Bhukha Devi. And दूसरे पक्ष लिखते हैं महेश्वर पांडे.
ठीक है, महेश्वर पांडे.
Son of Bhuneshwar Pandey.
Son of
Bhuneshwar Pandey जो भूखा देवी इनको लाए प्रॉपर्टी को मैनेजमेंट देखने के लिए, खेती बाड़ी करने के लिए. भुवनेश्वर पांडे. बागेश्वर पांडे. Son of Bhuneshwar Pandey. तीन आदमी थे इसमें.
Yes.
तीन आदमी थे.
तो इनके common ancestor कौन है?
In
Who is the common ancestor of all these persons?
the common, according to us, the Perul Pandey had two sons, Horil Pandey and Bechu Pandey.
So who is the common ancestor of these persons? भाई प्रॉपर्टी में एक कॉमन एंसेस्टर होगा तभी ना जॉइंट फैमिली प्रॉपर्टी होगा. Who is the common ancestor? Peru Pandey
was the common ancestor of the parties laws.
Peru Pandey. Common ancestor.
Ancestor of the parties laws.
Okay. How is Dakshineshwar Pandey related to Peru Pandey? Or Kinu Pandey related to Peru Pandey?
Yes.
How is?
Yes.
Yes.
The Peru Pandey was the common ancestor of the parties laws. He had two sons, namely Horil Pandey and Bechu Pandey also.
Yes.
And after death of Horil Pandey bought the land of Manikpur, Jasiti, and Bechu Pandey bought the lands of Nawadi, Silpari. The Horil Pandey had one son, namely Chua Pandey. And Chua Pandey had two sons, namely Sri Ram Pandey and Durga Pandey. And Sri Ram Pandey died issueless. And Durga Pandey had one son, Kinu Pandey.
Durga Pandey had one son.
Durga Pandey was the son of Sri Ram Pandey.
Okay.
And Sri Ram Pandey was son of Chua Pandey. And Chua Pandey was the son of Horil Pandey.
Okay. So Kinu Pandey and Dakshineshwar. How Kinu Pandey was the son of?
Kinu Pandey is the son of
Durga
Pandey.
And what about Maheshwar Pandey and Bageshwar Pandey?
Maheshwar.
And who is the father of Bhuvneshwar Pandey?
Maheshwar Pandey.
Who is the father of Bhuvnesh?
Yes. Shivlal Pandey Lordship.
Bhuvneshwar Pandey is son of
Shivlal Pandey.
Shivlal Pandey.
Ji.
And how is Shivlal Pandey related to
Yes. There
this
are two
Piru
sons.
Pandey?
Yes, there are two sons of the Peru Pandey Lordship. One Horil Pandey and Bechu Pandey. Bechu Pandey died leaving behind of Dhiko Pandey, and Dhiko Pandey died leaving behind Shivlal Pandey. And
So
Shivlal.
just a moment. So they are the descendants of Bechu Pandey.
Yes. Correct.
And Dakshineshwar Pandey is a descendant of Horil Pandey.
Yes. Yes.
Dakshineshwar Pandey is a descendant of Horil Pandey.
Yes.
And the second party is descendant of Bechu Pandey.
Bechu Pandey. Correct.
Now there is a partition between the descendant of Horil Pandey and descendant of Bechu Pandey.
Bechu Pandey. This is the case of the plaintiff.
That's right. You are the plaintiff.
I am the
Now you say that there, in your plaint only you say that there was a partition between Bechu Pandey and Horil Pandey.
Yes.
Once there is already a partition between Bechu Pandey and Horil Pandey, then under what circumstances there can be another partition between the descendants of Horil Pandey and descendants of Bechu Pandey?
Because Lordship, we can see page 4 Lordship. Page 4 of the Limited Affiliate Court Lordship. Leading the pardon.
No, we will see that. You just tell us. When, as per the plaint,
Yes.
there was already a partition between Horil Pandey and Bechu.
But they denied.
No, they might have denied. This factum of partition has been denied.
Yes.
Has been held to be incorrect.
No. According to defendant, they are
You
no
forget about the defendant. I am asking about the plaintiff. When the plaintiff has stated that there was already a partition between Horil Pandey and Bechu Pandey, then kindly explain how can
Yes.
there be another family arrangement
Yes, I am explaining.
between the family members of Horil Pandey and Bechu Pandey.
I am explaining Lordship. Page 4 Lordship, in middle of the Lordship, I am reading. The plaintiff, Bageshwar and defendant number 4, Maheshwar Pandey decided to enter into family arrangement. According to family arrangement, Dakshineshwar Pandey got 6 acres for dismiss and plaintiff Bageshwar Pandey and defendant got 13 acres. तो जो 13 एकड़ तो फैमिली अरेंजमेंट मिला उसका तो पार्टीशन होगा ना हमारा अकॉर्डिंग टू फैमिली अरेंजमेंट डीड उसका तो होगा ना ये तो जॉइंटली हो गया हमको तो 13 सॉरी प्लेंटिफ जो है बागेश्वर पांडे डिफेंड
The family arrangement, you might base this question, you just let me know. When you say that there was already a partition between Horil Pandey and Bechu Pandey, then how can the descendants of both of them, there can be another partition which is between?
therefore I am explaining lordship according to family arrangement did lordship 6 acres land was given to Dakshineshwar Pandey lordship
Yes.
and 13 acres 93 dismissed land was given to Bageshwar Pandey and the defendant Maheshwar Pandey. तो उसमें से हमको तो मिलेगा ना आधा.
भाई वो जो family arrangement है, which has been disbelieved by the court.
Not disbelieved by the court. No.
There is a family arrangement. For the family arrangement, there has to be a common ancestor where there has been no partition. Right? You say that you have a common ancestor called Peru Pandey, who had 2 sons, and there was already a partition between both of them. Right?
But
so their branches are completely separated from each other. Then under such circumstances, how can there be a fresh family arrangement between these 2 branches? How do they merge again?
But it is true that the family partition what executed lordship.
Might have been.
But it is a registered document.
Maybe every registered document is a gospel truth.
Lordship, yes. unless and until it is set aside by the competent court of civil jurisdiction lordship. The registered document got its own sanctity lordship.
That's right.
Yes, lordship may any issue claimed by the London trial court lordship.
No, you just come, alright, issued by the trial court.
London trial court lordship.
You come to the point for determination by the appellate court. You
Yes.
come to the trial court.
Points has not been formulated. Issues recasted by the London trial court. Same issue.
Okay. You come to this
Para six.
para number 6,
Para
para
six.
number 5 first.
Para number 5.
You just tell us for the point which we are under consideration.
Yes, the issue number 3, 4, 6 and 7, and same issue was also decided by the London trial
3,
court.
4, 6 and 7, right?
3, 4,
3,
6,
4,
6, 7.
6 and 7.
Now, Lordship, may I see the trial court judgment laws?
First the trial court judgment.
Trial court judgment laws.
Trial court also took up all these issues together.
Yes, which is in favor of the plaintiff.
Yes, please read it.
Yes, I am reading. Supreme trial court findings. The findings is page number 9, Lordship. वाद संख्या 3, 4, 6, 7.
6 and 8.
3, 4, 6, 7.
8.
ठीक
Next line take.
है। इसमें लगता है टाइपिंग अच्छी है 6, 8. Correct.
6, 7, 8.
Yes.
8 we have,
Yes.
which is the partition.
Yes.
wala. That is also there.
Yes. पैरा 4 लॉ से अभी रीडिंग। इस वाद में सबसे पहले वाद पद संख्या 3, 4, 6, 7, 8 विचारण हेतु एक साथ लिए जाते हैं। वाद में वादी की ओर से 14 साक्षी अनुसाक्षी आए हैं, जिसमें वादी साक्षी संख्या 1 बलेश्वर दास एंड साक्षी संख्या 2 ईश्वरी यादव है। इन दोनों साक्षी ने वादी कथन का समर्थन किया। वादी साक्षी संख्या 3 भैरव प्रसाद इन्होंने देवघर अंचल के कर्मचारी श्री शंकर सिंह की लिखावट एवं हस्ताक्षर का पहचान करके रसीद करते हैं, जिसे प्रदर्श 1 अंकित किया गया। रसीद प्रतिवादी संख्या 1 दक्षिणेश्वर पांडे एवं भुवनेश्वर पांडे वादी के पिता के नाम से। वादी संख्या 4 शत्रुघ्न सिंह है। ये एक औपचारिक साक्षी है। इनका कथन है कि मानिकपुर गांव में ठाकुर बाड़ी नहीं देखा। वादी संख्या 5 मंगल तुरी एंड वादी संख्या 6 राधे श्याम है। दोनों भी औपचारिक साक्षी हैं। वादी संख्या 7 भगवान रावत है। इनका कथन है कि मानिकपुर मौजा की जबरबंदी रैयत है। बागेश्वर पांडे को जानते हैं, दोनों भाई हैं। वादी संख्या 8 गोविंद मंडल, ये भी एक औपचारिक साक्षी है, जिन्होंने उच्च विद्यालय जर्सी की देवघर कार्यालय में लिखित सरयू मांझी की लिखावट हस्ताक्षर को पहचान स्थानांतरण प्रमाण पत्र दिए। इसे प्रदर्श 2 अंकित किया गया। यह स्थानांतरण प्रमाण पत्र दक्षिणेश्वर पांडे पिता महेश्वर पांडे ग्राम मानिकपुर का। वादी संख्या 4 सुनील देव है। ये भी औपचारिक साक्षी है, जिन्होंने देवघर जामताड़ा सरकारी केंद्रीय सहयोग समिति लिमिटेड के सचिव भुवनेश्वर पांडे की लिखावट एवं हस्ताक्षर को पहचान किया, जिसे प्रदर्श 3 अंकित किया गया। जो बागेश्वर पांडे वादी के नाम से है। वादी संख्या 10 निरंजन कुमार वर्मा, ये औपचारिक साक्षी देवघर अंचल की जन सेवा की लिखावट हस्ताक्षर को पहचान निर्वाचन कार्ड को करते हैं, जिसे प्रदर्श 4 के अंकित किया गया। निर्वाचन कार्ड बागेश्वर पांडे महेश्वर पांडे के नाम से, जो ग्राम मानिकपुर से संबंधित है, जिससे पीड़ित होता है मानिकपुर से संबंधित है। वादी संख्या 4 कृष्ण नंदन वर्मा, ये भी औपचारिक साक्षी के मूल्य देवघर अंचल के कर्मचारी मणिभूषण सिन्हा की लिखावट हस्ताक्षर को पहचान कर रजिस्टर रसीद दिए हैं। प्रदर्श 1 में अंकित किया गया है। दक्षिणेश्वर पांडे प्रतिवादी संख्या 1 भुवनेश्वर पांडे वादी के पिता के नाम से सही रूप से। वादी संख्या 12 रमेश कुमार यादव है। ये भी औपचारिक साक्षी है, जिन्होंने देवघर के नरेश्वर पांडे की लिखावट हस्ताक्षर पहचान लिए, जिसे प्रदर्श 4 अंकित किया गया। प्रदर्श लाख देखने से विदित होता है कि निर्वाचन बोर्ड की कानून कॉपी साक्षी संख्या 13 बागेश्वर पांडे, जिसमें वादी है। इनका कथन है कि उन्होंने संपत्ति के बंटवारे के लिए वर्तमान मुकदमा स्थापित किया, जो ग्राम मानिकपुर में उपस्थित है। मानिकपुर की संपत्ति भूखा देवी के नाम से दर्ज है। भूखा देवी नावद वर्गी, इनके पति का नाम किमू पांडे है। पैरू पांडे के 2 बेटे हुरी एंड बेचू है। भूखा देवी हुरी पांडे के वंशज है। ये लोग बेचू पांडे के वंशज है। हुरी पांडे और बेचू पांडे में आपसी बंटवारा हो गया था। मानिकपुर के संपत्ति बेचू पांडे को मिला। किमू पांडे की विधवा पत्नी खेती करने लायक नहीं थी, क्योंकि वो कर्जन नसीब थे। तो उसने अपने देवर सुरेश्वर पांडे उनके पिता को लाकर यहाँ बसाई हुई और वहाँ खेती बाड़ी करते हैं। मानिकपुर इनके पिता परिवार के साथ रहते हुए भूखा देवी के ही मकान में रहते। भूखा देवी की मृत्यु के बाद उसके सारे जमीन इनके पिता नागेश्वर मिलकर दखल करते थे। अभी भी भूखा देवी की जमीन को दखल करते हैं। भूखा देवी के मकान में इनके हिस्से में रहते हैं। ग्राम मानिकपुर वही स्टेट के अंदर आता है। तो वही स्टेट बिहार सरकार में विलय हुआ तो भूखा देवी और भुवनेश्वर पांडे का रिटर्न इन लोगों के नाम से दिया गया। भूखा देवी की ओर से उनका मालगुजारी और उसके पिताजी और बाद में ये लोग रहते थे। अंचल के पर्चा में भी विवादित जमीन भुवनेश्वर पांडे भूखा देवी के नाम से दर्ज है। वादी दक्षिणेश्वर पांडे के बीच निबंधन पारिवारिक व्यवस्था हुई है। व्यवस्था के अंदर कितना जमीन मिला ये दर्ज है। पारिवारिक निबंधित व्यवस्था पर न्यायालय में दाखिल है। उसी के हिसाब से सभी लोग संपत्ति के दखलकार है। पारिवारिक व्यवस्था के प्रत्येक पृष्ठ पे का हस्ताक्षर है जिसे लीड राइटर ने लिखा। प्रदर्श 5 से 5 आई तक अंकित किया गया। एलआरडीसी और डीडीसी का मुकदमा हुआ था जिसे हार गया। प्रतिवादी करना है होली पांडे के पिता का नाम गौर पांडे। प्रतिवादी के भी का गलत है कि इनका खानदान भूखा देवी का खानदान अलग है। प्रतिवादी का यह कहना गलत है कि विवादित संपत्ति दखल में लोग नहीं आए। प्रति परीक्षण में इनका कथन है कि पारिवारिक व्यवस्था से एवं भूखा देवी कोई झंझट नहीं हुआ था। मौजा से की जमीन को पारिवारिक व्यवस्था में नहीं लिया गया जो पैतृक है। तीनों पांडे अपनी विधवा पत्नी भूखा देवी लड़के बाबूलाल पांडे को छोड़कर मर गए। भूखा देवी के नाम से विवादित संपत्ति तक बाद में भूखा देवी वादी के पिता के नाम से जमींदारी में को रजिस्टर में दर्ज किया गया। भूखा देवी ने दक्षिणेश्वर पांडे को पोषपुत्र को लिया था। उनका कथन है 1965 वाले टाइटल सूट में पंचनामा का कागज दाखिल नहीं किया गया था। वादी संख्या 14 आनंद बल्लभ सहाय ये औपचारिक है तथा डीड राइटर है। जिन्होंने निबंधित पारिवारिक व्यवस्था पद्धति बल्लभ सहाय का हस्ताक्षर लिखावट को पहचान करते हैं। इसे प्रदर्श 3 अंकित किया गया। प्रदर्श 5 अनुच्छेद को पारिवारिक व्यवस्था पत्र 5/12/1980 को निबंधित हुआ था जिसमें दक्षिणेश्वर पांडे अन्य साक्ष्य अन्य लोगों में हस्ताक्षर है। मेरा ये निबंधित था। इसी स्थिति में अस्वीकार नहीं किया जा सकता है। इसी प्रकार से प्रतिवादी को 7 साक्षियों को साक्ष्य कराया गया जिसमें प्रतिवादी संख्या 1 सुरेंद्र लाल बर्नवाल। उनका कहना है विवादित जमीन भूखा देवी पर्चा में भूखा देवी के नाम से है। भूखा देवी जब तक जिंदा थी उसके कब्जे में थी। दक्षिणेश्वर के भोजपुत्र है। भूखा का बने हुए दक्षिणेश्वर जमीन में दखल इन कब्जा में आए। बागेश्वर महेश्वर ग्राम नावाडी सिरथिरी में रहते हैं। ग्राम मानिकपुर में रहने वाले संपत्ति बागेश्वर महेश्वर कोई सरोकार नहीं। दक्षिणेश्वर पांडे के नैसर्गिक पिता महेश्वर पांडे है। प्रतिवादी संख्या 2 सहदेव महतो है। इनका कहना यह है कि भूखा देवी को जानते हैं। दिवाली के दिन पर्चे में भूखा देवी के नाम से भूखा देवी दक्षिणेश्वर को पोषपुत्र लिया। भूखा का मरने के बाद दक्षिणेश्वर भूखा देवी की जमीन को दखल करता। विवादित संपत्ति भुवनेश्वर और महेश्वर के दखल में ये लोग मानिकपुर गांव में रहते भी नहीं। ठाकुरबाड़ी के घर के अंदर है जबकि वादी के साक्षी कथन ठाकुरबाड़ी है नहीं। प्रतिवादी संख्या 3 पंचानन मोदी कथन भूखा देवी जमीन पर्चा भूखा देवी के नाम से भूखा देवी सड़क खेती करवाती थी। भूखा देवी दक्षिणेश्वर पांडे प्रतिवादी संख्या को भोग किया था और उसकी मृत्यु के बाद उसका संपत्ति में दखल करते हैं। उनका कथन है कि भूखा देवी का ठाकुरवाड़ी परंतु ठाकुरवाड़ी में किस चीज की मूर्ति नहीं कर सकते। प्रतिवादी संख्या साक्षी 4 1 लाख यादव। इनका कथन है कि भूखा देवी के खानदान के लोग इनको पुरोहित थे। उनकी संपत्ति के जो स्वयं करते थे। भूखा देवी को ठाकुरवाड़ी भी है। भुवनेश्वर पांडे शिवपुरी मौजा के रहने वाले थे। अभी ठाकुर और दक्षिणेश्वर पांडे पूजा पाठ करते हैं। वादी विवादी जमीन का दूरवास नहीं करते। वादी नहीं करते। प्रति परीक्षण उनका कहना इंपॉर्टेंट है कि प्रोपोज करने के समय से भुवनेश्वर पांडे को पूजा पाठ करते देखा है। पूजा पाठ भूखा देवी भी करती थी। उन्होंने वादी के ही कथन का समर्थन किया है। ये एडमिटेड कथन है। ठाकुरवाड़ी के काली माई की मूर्ति है। 3 वर्ष से ऊपर दक्षिणेश्वर पोषपुत्र लिए हैं जबकि पोषपुत्र का कागज कई वर्षों से पहले निबंधित किया गया। प्रतिवादी साक्षी संख्या 5 गौरी शंकर वर्णवादी का औपचारिक साक्षी जिन्होंने कर्मचारी श्री शंकर सिंह के लिखावट हस्ताक्षर को पहचान और खजाने का रसीद पर दिए गए जिसे प्रदेश के अंकित किया गया। प्रदेश के दक्षिणेश्वर पांडे प्रतिवादी संख्या 1 के नाम से 10/1991 का है। प्रतिवादी साक्षी संख्या 6 दक्षिणेश्वर पांडे पूरे गणक तकरारी जमीन भूखा देवी के नाम से। भूखा देवी इनको पोषपुत्र लिया है। गौरी पांडे का नाम सुनना। उनका बेटा का नाम चोबा पांडे है। चोबा पांडे के 2 बेटे राम पांडे और दुर्गा पांडे। राम पांडे नवाला मर गए। दुर्गा पांडे में एक बेटा जिसका नाम किनू पांडे है। यही भूखा देवी के पति किंतु पांडे किनू पांडे के पर्सनल सेटलमेंट से पूरी मर गए थे। भूखा देवी को अपना लड़का बाबूलाल पांडे था जो अपनी माँ की मृत्यु से पूरी मर गया था। भूखा देवी उसके पति किनू पांडे को बागेश्वर
भूखा देवी का
बेटा जो है उनकी मृत्यु, भूखा देवी की मृत्यु से पहले ही उसका बेटा मर गया ना।
दक्षिणेश्वर को तो अडॉप्ट किया
एडॉप्ट
था।
किया उसने।
और
जी,
बेटा मरने के बाद
बेटा मरने के बाद
इनका कैसे है कि बेटा मरने के बाद एडॉप्ट किया। हमारा है कि वो डाइड इशूलेस, भूखा देवी डाइड इशूलेस। कोई गोविंद पांडे का भाई बैचू पांडे नहीं है, ये लोग आपस में गोटिया भाई नहीं थे। भुवनेश्वर बागेश्वर पांडे को मानिकपुर में कोई जगह नहीं है। इसी प्रकार भूखा देवी को ग्राम नावाडी और सिरसिरी में कोई जगह जमीन नहीं। भूखा देवी को मरने के बाद उसके जमीन का जो आबादी प्रतिवादी करते थे, भूखा देवी पर्दानिशी महिला नहीं थी, उसमें खेती बाड़ी करते थे। भूखा देवी भुवनेश्वर पांडे थे, अपने ठाकुर बाड़ी में पूजा पाठ कराती थी। यह बात गलत। भुवनेश्वर पांडे मानिकपुर में बस गए थे, गलत से रजिस्टर में भुवनेश्वर पांडे का नाम मिली भगत करके चढ़ा दिया गया, जिसे बाद में रद्द कर दिया गया। बागेश्वर पांडे वगैरह जो बंटवारा से संबंधित कागजात न्यायालय में दाखिल किया गया है वो जाली है। भूखा देवी का सारा जमीन उनके दखल में है, वाद बहुत दिनों से बेदखल है, वादी बहुत दिनों से बेदखल है, इसलिए विपरीत कब्जे के आधार पर ये बाहर है। प्रति परीक्षण में कथन है कि नैसर्गिक पिता से वादी छोटे हैं। आज तो 15-20 वर्ष पूरी गोविंद पांडे की जानकारी हुई जो इनके पिता से मालूम था। भूखा देवी कम मरा नहीं कर सकते हैं, इनकी नैसर्गिक माँ की मृत्यु 1 वर्ष पहले हुई थी, वे मानिकपुर में नहीं मरी, उसके श्राद्ध में भी नहीं किया था। अनिरुद्ध पांडे इनके नैसर्गिक माँ को मुखाग्नि में दिया था, ये पुष्पुत्र से दावा कर रहे हैं। डाक नंबर 594 भूखा देवी का मंदिर है, बाड़ी का रखवा नहीं कर सकते। भुवनेश्वर पांडे भूखा देवी के मंदिर में पूजा पाठ करते नहीं देखा। भूखा देवी के मंदिर की समय की उम्र 7 वर्ष थी। बागेश्वर पांडे महेश्वर पांडे के बीच भूखा देवी के संपत्ति को लेकर पारिवारिक बंटवारा नहीं हुआ था। प्रदेश 6 में जो पारिवारिक व्यवस्था पत्र है उसमें कुछ तो ऐसा हस्ताक्षर नहीं है, सो प्रत्येक पृष्ठ पर हस्ताक्षर है जिसे इनकार करते हैं। पारिवारिक व्यवस्था पत्र जारी है, उनको आगे घोषित करने के लिए ना तो सिविल कोर्ट में मुकदमा किया है, ना ही इसके लिए आपराधिक मुकदमा किया है। इनके अनुसार कोई पारिवारिक बंटवारा नहीं है, ऐसा नहीं कर सकते कितना जमीन मिला, कुछ जमीन के कब्जे में है। फिर इनका कथन गलत पारिवारिक व्यवस्था कहीं भी शिकायत नहीं किया। भूखा देवी मंदिर में शालीग्राम विष्णु अन्य देवताओं का मूर्ति, जबकि प्रतिवादी साक्ष्य के 4 टेकलाल यादव कथन है भूखा देवी को ठाकुरबाड़ी में स्थित काली माँ की मूर्ति है। प्रतिवादी संख्या 4 उधम प्रसाद मंदिर जो एक औपचारिक साक्षी है, उन्होंने कर्मचारी श्री शंकर श्री के कार्ड हस्ताक्षर को पहचान के प्रदर्श A by 1 अंकित किया गया। इसे प्रदर्श को लेकर विद्युत रसीद दक्षिणेश्वर पांडे के नाम से। प्रतिवादी को टाइटल अपील संख्या का आदेश देना 5 किलोमीटर को सच्ची पत्र के लिए प्रदर्श भी दाखिल किया है। विद्युत उपयुक्त अपील रेगुलर में खारिज किया गया। इसी प्रकार रेगुलर मिसलेनियस केस संख्या 1392 में खारिज किया गया। इसी प्रकार रेगुलर मिसलेनियस संख्या 1392 दक्षिणेश्वर पांडे बना महेश्वर पांडे के विरोध है। दिनांक 27/1/93 आदेश को सचिव अधिकर्मानुक प्रतिलिपि दाखिल किया, जिसे विद्युत भूमि सुधार समाहर्ता मानिकपुर मौजा के मंदिर नंबर 67 भुवनेश्वर पांडे के नाम के इंदिराज विहित प्रक्रिया नहीं किए जाने के कारण उनका नाम उपयुक्त विनाश से काटने के लिए निर्देश पारित किया गया था, जिसे कर्मचारी को प्रतिनिधियों के नाम को चढ़ाया गया था। उसके विरुद्ध कानूनी कार्रवाई करने की अनुशंसा किया गया। उन्होंने भी आदेश पारित किया कि जब तक कानूनी व्यवस्था का नामांकन स्वीकृत नहीं होता तब तक जन्ममंडी नंबर 67 में केवल दक्षिणेश्वर पांडे का नाम स्वतंत्र रूप से कायम रहेगा। प्रदेश B/3 से विद्युत भूमि सुधार संस्था का आदेश दिनांक 27/1/93 को उपायुक्त संतुष्टि किया। प्रदेश C&D टाइटल सूत्र में 41/65 के निर्णय डिग्री सचिव अभी प्रमाणित प्रतिलिपि है। प्रदेश EF चर्चा का कॉपी। दोनों पक्षों के साक्षियों को साक्ष्य अवलोकन में पाता हूँ। भुवनेश्वर पांडे भूखा देवी के पति तीनू पांडे के उत्तर भोगी गोतिया होने के कारण भूखा देवी कहने पर विवादग्रस्त जमीन संपत्ति का देखभाल करने के लिए ग्राम मानिकपुर मौजा माने से वहीं बस गए। अभिलेख से भी भुवनेश्वर पांडे को मौजा मानिकपुर गाँव में बसने के समय भुवनेश्वर पांडे और उनका लड़का बागेश्वर पांडे को दक्षिणेश्वर पांडे ने नैसर्गिक पिता है। भूखा पांडे के बाद जमीन संपत्ति को विजुअल संपत्ति के रूप में दखल रहे। अभिलेख इन दोनों पक्षों के साथ
इसको थोड़ा फिर से पढ़िए। अभिलेख से ये विदित होता है कि भुवनेश्वर
अभिलेख से विदित होता है भुवनेश्वर पांडे को मौजा मानिकपुर गांव में बसने के समय से ही भुवनेश्वर पांडे और उनके लड़के बागेश्वर पांडे महेश्वर पांडे जो दक्षिणेश्वर पांडे के नैसर्गिक पिता हैं। भूखा देवी के वादग्रस्त जमीन संपत्ति
ये एक सेंटेंस में क्या मतलब? भुवनेश्वर पांडे को मौजा मानिकपुर गांव में बसने के समय से ही भुवनेश्वर पांडे और उनका लड़का बागेश्वर पांडे, आगे महेश्वर पांडे जो दक्षिणेश्वर
वहीं पर रहते थे। भूखा देवी को बात करें जमीन और संपत्ति को
महेश्वर पांडे दक्षिणेश्वर पांडे के यानी कि महेश्वर पांडे
biological
is
father
husband of
महेश्वर पांडे
okay Maheshwar Pandey is a descendant of Bachchu
बेचू
Bachchu
बेचू पांडे
Bachchu Pandey descendant
अभिलेख हम दोनों पक्षों के साथ यह भी विदित होता है कि दिनांक 5/12/1980 को दोनों पक्षों के बीच पारिवारिक व्यवस्था बना था जिसको दक्षिणेश्वर पांडे का हस्ताक्षर है। इन पारिवारिक व्यवस्था पत्र निबंधित है। उसकी पारिवारिक व्यवस्था से यह भी विदित होता है कि पांडे भूखा देवी की मृत्यु के पश्चात भूखा देवी का अनेक तरह के झंझट होने के कारण एक पारिवारिक व्यवस्था पत्र का आधार पर उन्होंने अपने देवर भुवनेश्वर पांडे उनके परिवार को मानीपुर में 1935 साल बंगला में लाकर बसाया था कि भूखा देवी सब संकट टल सके संपत्ति की रक्षा हो सके जिसके द्वारा भुवनेश्वर पांडे बंगला साल 1935 से मानिकपुर में मकान बनकर रह रहे थे। भूखा देवी के पति को मरने के बाद भूखा देवी निसंतान हो गई अतः उसने वंश रक्षा के लिए भूखा देवी ने दक्षिणेश्वर पांडे को 1964 में पोस्ट को दिया जिसे निबंधित कराया गया। भूखा देवी के हर पक्षकारों को दखल बराबर स्वीकार करती रही जिसके आधार पर वादी के पिता का नाम दर्ज हुआ खजाना भी देते रहे। भूखा देवी की मृत्यु के पश्चात सभी पक्षकार लोग भूखा देवी की संपत्ति का दखल करते आ रहे। दोनों पक्षों के बीच संपत्ति को लेकर झंझट होते रहते थे जिसके कारण आपस में पारिवारिक व्यवस्था दिनांक 5/12/1980 को बनाकर भूखा देवी की संपत्ति को उपवास करते रहे। पारिवारिक व्यवस्था को दक्षिणेश्वर पांडे और प्रतिवादी संगठन के साथ पक्षकारों साक्षियों का हस्ताक्षर है इसे नकारा नहीं जा सकता। यह भी मैं पाता हूँ दिनांक 5/12/1980 की पारिवारिक व्यवस्था पत्र का आधार पर उभय पक्ष जमीन को दखल जो बात करते रहे तब मैं पाता हूँ वाद संख्या स्वयं सोचना आदि के प्रश्न मिलने के
So in spite of this parivarik vyavastha they continue to be in joint possession
नहीं उसके बाद तो फिर अलग हो गया but just joint position is correct joint position therefore left is suit was right therefore suit was right
suit was filed no more
so declaration suit was filed to declaration the plaintiff have valid right title interest over the civil B land to the extent of their half share in confirmation of
basically partition suit was filed in spite of this parivarik vyavastha
it is absolutely partition should also for declaration of right title interest on the basis of half share
so you are seeking partition only
yes
so there is already a parivarik vyavastha but still you are seeking partition a registered parivarik vyavastha
it is a joint after execution of the family arrangement in law it is a joint property law therefore need of partition
so by virtue of that family arrangement it became a joint property
became the joint property law
so or it was always the joint property there are two things there are two branches right by virtue of family arrangement it became the joint property
yes it became the joint property why I am saying lordship make any judgment of the learned first appellate court lordship peace court lordship it has mentioned that the plaintiff so Dakshineshwar got 6 acres land lordship and Bageshwar and Maheshwar Pandey got 13 acres something lordship
by virtue of family arrangement
by virtue of family
then
arrangement
buy a fresh partition suit
because there is a family there after execution of the family arrangement there was a quarrel between the parties they therefore lordship filed a partition suit lordship
there was already a partition there was no need for fresh partition
need lordship why need because there
you will simply go for declaration of title
but yes but the declaration of title is also in this release law
must be
yes
but you are seeking partition also
both lordship declaration of right title interest and
partition
partition
already
law
been partitioned as per family arrangement then buy a fresh partition suit
because there is a quarrel between the parties therefore lordship there is a need of partition law there are 4-5 read of the partition suit lordship first for declaration of plaintiff have valid right title interest over the schedule B land to the extent of their half share confirmation of their possession second partition of half share third declaration that defendant number
partition of half share or partition
of
half share
half share because the 13 acres land was given to the plaintiff and the Maheshwar Pandey therefore lordship partition suit was
to the plaintiff and Bageshwar Pandey and Maheshwar Pandey
Maheshwar Pandey.
by virtue of this partition.
By virtue of this partition.
This partition. So it was given jointly to them.
Jointly. जैसे से ब्रांच बढ़ेगा तो पार्टीशन तो होगा ही.
The plaintiff was adopted by Mukhadevi.
No.
Or father of plaintiff.
The defendant number 1 adopted by Kinu Mukhadevi.
Okay, defendant number 1.
Dakshineshwar Pandey. Meaning they
So
are
Dakshineshwar Pandey,
meaning they are when the Dakshineshwar Pandey is
the father of the biological father of Dakshineshwar Pandey was Mahesh Pandey. Maheshwar Pandey. And Dakshineshwar and the otherwise his father was Kinu Pandey.
Kinu Pandey. Correct.
Since he was adopted by
Adopted.
Mukhadevi. And what is the name of father of Maheshwar Pandey?
Maheshwar Pandey. Maheshwar Pandey father is the Bhuvneshwar Pandey.
Bhuvneshwar Pandey. And who is the father of Bhuvneshwar Pandey?
Shivlal Pandey.
Shivlal Pandey.
And Shivlal Pandey is the son of Bhiko Pandey.
Bhiku Pandey.
Bhiko Pandey. And Bhiko Pandey was the son of Becho Pandey. Horil Pandey and Becho Pandey. There are two brothers.
Pandey. He is the son of Bechu Pandey.
Bechu Pandey. There are two Perul Pandey had two sons, Horil and Bechu.
So just a minute. While explaining the genealogy, the learned counsel for the appellant has submitted that Peru Pandey is a common ancestor. He had two sons, one Horil and other Bechu. The property in Manipur was, there was a partition between Horil and Bechu, and the property in Manipur was allocated. Manipur was allotted to Bechu Pandey.
No, Horil Pandey.
Horil Pandey.
Horil Pandey.
Was allotted to Horil Pandey.
And property of Nawadi.
And property of
Nawadi
was allotted to
Bechu Pandey.
Bechu Pandey. The suit property is situated in Manipur.
Devghar, district Devghar.
District तो Manipur है कि
Manipur, Jasi.
Okay, the suit property is located in Manipur,
Jasi.
Jasi. He submits that son of that Bhika Pandey was son of Bechu Pandey. Shivlal Pandey was son of Bhika Pandey.
Bhiko Pandey.
Bhiku.
Bhiko.
Bhiko.
Bhiko Pandey.
Bhiko Pandey.
Bhiko Pandey was son of Bechu Pandey.
Right. And Bhuvneshwar Pandey was son of Shivlal Pandey. Further, Maheshwar Pandey was son of Bhuvneshwar Pandey. And Dakshineshwar Pandey was the biological son of Maheshwar Pandey. The further case is that Kinu Pandey was the descendant of Horil Pandey. His wife was Guki Devi, Guko Devi, and Dakshineshwar Pandey was the adopted son of Guko Devi. Guka Devi.
BHUK.
K. Guka Devi.
Adopted on 22/9/1964.
Adopted on 22/9/1964.
1964.
He has also submitted that a registered deed of partition.
One case also. Bukha Devi died on 1/1/1965.
Guka Devi died on 1/1/1965. He has also submitted that one registered partition deed dated 5/12/1980 was entered into between Dakshineshwar Pandey on one hand and Maheshwar Pandey and Bageshwar Pandey, both sons of Bhuvneshwar Pandey on the other hand. Meaning thereby that the family arrangement was made between the branch of Horil Pandey and Bhattu Pandey. Although, as per the case of the plaintiff, they got separated. Horil Pandey and Bhattu Pandey were already separated, and Horil Pandey got the property in Manipur, and Bhattu Pandey got the property in Nawada. So there is a reunion of the. The learned counsel submits that by virtue of the registered family arrangement dated 5/12/1980, which dealt with the properties of Manipur, Jasidi, there was a reunion between the branches of Horil Pandey
And
Bhattu Pandey. So you are claiming reunion
Yes.
by virtue of this.
Yes.
The trial court gave a finding that
In my favor,
where is that final finding?
page 16 of the type of
Page 16.
आता मैं ये पाता हूँ कि बात पद संख्या 3, 4, 6, 7 एवं वादी के पक्ष में निर्णय किया जाता है।
Reunion का तो कोई इशू नहीं बना है.
नहीं कोई इशू नहीं।
But the entire story is of reunion.
Reunion. Correct.
What about the first appellate law?
Para 15 laws of findings. Although points have not been formulated, the recasted the issue of the London Trial Court. Para 15 laws. Findings.
Para 15.
Para 15 page 19 laws.
Page 19.
Page 19 laws. Internal page 19 laws.
Yes.
Para 15.
Yes.
Yes. The counsel appearing for the appellant defendant in course of his argument contended that the findings of the learned court below are against the material of the record and completely ignored the law in fact. He further argued there is no evidence of the record to show that Pelu Pandey was the father of the Gori and Bechu Pandey. The It is clearly mentioned para 11 of the exhibit C, judgment of the trial court so and so number that Gauri Pandey and Bechu Pandey were not full brothers, not able relation. Therefore, genealogical table given by the plaintiff respondent. So, a Peru Pandey as father of the Horul Pandey and Bechu Pandey is called. The father contended the Horul Pandey was the son of the Gaur Pandey and Bechu Pandey was the son of Peru Pandey. Therefore, the Bechu Pandey had no any concern with the family of the Horul Pandey as they belong to the different branches. The family settlement exhibits is
As they belonged to different families, not branches.
no, it has mentioned
Mention branches.
they
But
are not
meaning
not
that
two brothers and not even relation.
no relation.
No relation.
They completely denied the relation.
Yes, I am therefore reading you.
Yes.
Therefore, the Bechu Pandey had no any concern with the family of the Horul Pandey as they belong to different branches. एक तरफ बोल रहे no relation and other hand करें different
The
branches.
facts is revealing that
Yes.
their case was that they are not connected at all. Rather, it should have been
But
families.
other hand said that the Horul Pandey and they belong to different branches.
अरे भी बोलने से क्या हुआ? ये कोई statute नहीं है.
इनका स्टेट है हमारा स्टेट इनका.
That's right.
The family settlement exhibit 6 it is wrongly mentioned it should be exhibit 5 is the concocted and false.
Maybe उसके बाद 1920 Bhekku Pandey was absolute owner of the suit property. ये पढ़िए ना?
कहाँ से?
Page number 20.
Page number 20.
Therefore, Bhekku Pandey had no concern with the family of Horul Pandey as they belonged to different branches. Then Bhekku Devi was absolute owner.
Page number 20. The Buddha Devi was the absolute owner of the suit property. Germany number 67. It was indicated that Buddha Devi recorded in Ganges settlement that is GVE. The Red Court has also held in Exhibit C that Buddha Devi was in possession of the suit land till her death. The claim of the plaintiff appellant on the request of the Buddha Devi, Bhuveshwar Pandey came to Mother Mary Kaur and started living with her in possession of the suit and used to maintain the Buddha Devi. On the point of possession, except the plaintiff responded, no other witness has been examined to speak that Bhuveshwar or Bhuveshwar Pandey in possession of the suit. The learned counsel further contended the case of the plaintiff responded mainly based on the family settlement. He contended that Bhuveshwar Pandey, Bhuveshwar Pandey and Maheshwar Pandey have no concern with the family of the Kinu Pandey and Bhuka Pandey. They are the different branches and totally a stranger in the family of the Bhuka Devi. It has been held by the subject in title suit number. See, the Horil Pandey and Bechu Pandey were not the full brothers. Horil Pandey was the son of Gaur Pandey and Bechu Pandey was the son of Peru Pandey. And given the appropriate funding, title suit number 41 of 65, it is clear that Nageshwar Pandey responded to Maheshwar Pandey belonged to branch of Peru Pandey. So they are strangers to family of Bhuka Devi. The Nageshwar Pandey has not filed any sheet of paper to prove that he belongs to family of Bhuka Devi. In further argument, there is no family arrangement during the lifetime of Bhuka Devi. Bhuka Devi died in the year 1964 and family settlement was procured on 5/12/1953 to grant the property of the Bhuka Devi. Family settlement exhibit 6 is concocted and for and Dharmeshwar Pandey appellant was the instrument of the signature obtained on exhibit C under influence by the Bhageshwar and Maheshwar Pandey. But there is a no plea of lordship. Fraud.
Need not be. You see, two different families. They enter into a family arrangement.
But the elements of fraud is pleaded
Need
and
not
proved
be
by the
there.
cogent
Not you
evidence.
forget it. The records are revealing. There is already a finding in the earlier title suit that Horil Pandey and Bechu Pandey were not full brothers.
Maybe not full brother, but it is a registered family.
Maybe registered. We take care of that. You don't worry about it.
Registered document.
When the evidences are revealing that these two families are absolutely not connected with each other, wait, it is something like you enter into a family arrangement with him,
But after
having no connection, having no common ancestor.
after the death of Bhuka Devi, the Dakshineshwar Pandey inherited the property lordship.
How?
He
Yes,
was the sole owner.
that's right. He
And
was the sole owner.
And he put his signature in the family arrangement.
That makes no difference.
And then
That makes no difference because his biological.
But in WS
Because his biological father was Maheshwar Pandey.
yes,
Yes.
biological father is Maheshwar Pandey.
Got it.
This is my son.
आगे फिर इसको कंप्लीट करें.
अच्छा the family settlement is hit by the section 20 और 69 of the SPT Act. ये भी गलत है. इसमें तो SPT कोई ट्रांसफर नहीं हो रहा. दिस इज द बंटवारा. SPT का वायलेशन कब होगा? जब ट्रांसफर होगा. This is not transfer of the property, it is the partition of the property. Therefore, it is not violation of the section 20 and 60.
You just tell us, as a council, you tell us. For partition of the property, there has to be a common ancestor. Because in the case of partition, everybody is a co-owner of the property, right? So there can be a partition of the property. But when there is no common ancestor, then can there be a partition? Practically, this transaction by way of family settlement is a transfer by Dakshineshwar Pandey to his father Maheshwar Pandey and putting the entire family in entire property in common pool of Maheshwar Pandey and Dakshineshwar.
But the defendant did not challenge the family settlement deed lordship before the competent court of civil jurisdiction. Yes.
There is a presumption in connection with family settlement.
The Supreme Court held that any 2010 SC page 211, the Honorable Supreme Court held that any registered document, either void or voidable, which is required to be challenged before the competent court within the 3 years from the date of challenge.
Yes.
It did not challenge.
Please see. You read further. Complete.
Yes, the family settlement is held by the section 20 and 69 of the SPT Act. The plaintiff respondent never came in independent possession of the suit property on the basis of the said family settlement. As such, the plaintiff Bageshwar has no right, title, interest over the suit property. The defendant has relied upon the ruling reported in SPT Act 1949, section 20, so and so, so and so. All these are applicable in the present case. The appellant respondent, in order to prove his claim over the suit property, has filed document Exhibit 1 and Exhibit a rent receipt of Jamabandi number 67 issued in the name of Bhuneshwar Pandey and Dhatneshwar Pandey. Rent receipt is a note, a document of title. This is correct. Rent receipt is a note, a document of title, but rent receipt is showing evidence of possession of the land. The rent receipt note, the document of the right title interest, the Exhibit 3, receipt of the Devghar Jamtara Cooperative Samiti issued in the name of Bageshwar Pandey. Exhibit 4 by A are the voter list of the Moja Manikpur in the name of Maheshwar Pandey, Bageshwar Pandey and other. Exhibit 6 is the family settlement and Exhibit 7 is notice in which the Bhutta Devi was party received by the Bhuneshwar Pandey, the father of the Bageshwar Pandey. All these documents indicate that Bageshwar Pandey is residing in the village Manikpur, except the posted document. The plaintiff has not filed any sheet of paper to prove his claim. Prove his right, title, interest over the suit property. Therefore, the claim of the Dhatneshwar Pandey, he came in possession of the suit property after death of Bhuneshwar Pandey. His father and he have perfected his right, title, and interest over the suit case. The learned court below, to my mind, are in deciding the issue number so and so in favor of the plaintiff and respondent against the defendant appellant. I decided this issue in favor of the appellant, defendant against the appellant.
Dakshineshwar Pandey, he came in possession of the suit property after death of Bhuneshwar Pandey, his father. ये his father कैसे लिखते हैं? दक्षिणेश्वर father के तो पिताजी का नाम महेश्वर पांडे
होगा या कीनू पांडे
या कीनू पांडे होगा, ये तो गलत है ना?
गलत.
भुवनेश्वर पांडे तो नहीं होना चाहिए.
Absolutely wrong.
It has to be महेश्वर पांडे.
Yes, it's Maheshwar Pandey or कीनू Pandey.
The property. The property is of Manikpur.
Jasiti.
So it belongs to this Bhukha Devi. Right? Therefore, the plaintiff was the son of plaintiff.
Plaintiff is son of Shivlal Pandey or?
Oh, Bhuvneshwar Pandey.
जी, Shivlal Pandey.
Bhuvneshwar Pandey. Plaintiff is son of Shivlal.
And Sivalal Pandey was the son of Bhikkhu Pandey, and Bhikkhu Pandey was son of Bechu Pandey.
Plaintiff is the son of. And Dakshineshwar Pandey is plaintiff or defendant?
Dakshineshwar Pandey
Defendant.
defendant number 1. Defendant number 1 also.
Dependent on
Son of adopted son of Bhikkhu Pandey.
The plaintiff is the son of Shivlal Pandey and belongs to the branch of belongs to and is a descendant of Betu Pandey. Dakshineshwar Pandey is defendant number 1 in the present case, whose biological father belongs to the branch of Betu Pandey and Bhikkhu Devi, who belongs to the branch of Horil Pandey, had adopted Dakshineshwar Pandey. The descendant of the branch of Betu Pandey claimed half share of the property, which belonged to the branch of Holy Pandey.
On the basis of the Parivarik Batwara.
On the basis of
Family arrangement.
Family arrangement. Dated, क्या date is it?
1980 का.
Family arrangement, registered family arrangement of 1980.
1980.
The finding of the learned first appellate court is that Horil Pandey and Betu Pandey did not belong to the same family.
not son of Perumal.
And both were not sons of Betu Pandey.
This is the case
Different
of the
genealogy has been provided. आप बताइए क्या? अब substantial question of law पर एक बार.
Order number 4. Render the judgment of the lower appellate court reversing the finding of the trial court on the ground of family settlement having been entered into in the year 1980 after death of Bhikkhu Devi cannot be given effect.
अब इतना क्या बोलूँ? What do you have to say?
और पेज 17 फिर से एक बार पढ़ने जा रहे हैं appellate court का जजमेंट. पेज 17 last paragraph. Besides oral evidence, defendant has also filing document in support of the case. Exhibit B is the certified copy of order dated 5/3/73. The title appeal number 60 of 1968. It appears from the particular of Exhibit B. The said appeal was dismissed for default. Exhibit B2 is the photo state copy of order sheet of mutation case number 80 of 1966-67 in which Dakshineshwar Pandey was petitioner, had filed the said case before C.O. Devra for correction and removal of the name of the Dakshineshwar Pandey for register 2 regarding Jababandi number 67. Exhibit B2 certified copy of order dated 27/1/93 revision miscellaneous case number 13 of 1993 in the court of Sub-Divisional Officer Devgar Dakshineshwar Pandey versus Maheshwar Pandey and others. It clear from Exhibit B2 that name of Bhuvneshwar Pandey was wrongly recorded in Register 2 and an order was passed to remove his name from Register 2, and name of the Dakshineswar Pandey would continue in Register 2 until the acceptance of the family settlement for mutation. Further order was passed directing CO Devghar to institute a case against the Karmchari who recommended the name of Bhuneswar Pandey for entry in Register 2. Exhibit B3, certified copy of order sheet dated 22/4/93 of criminal miscellaneous case number 131/92/93, Bageshwar Pandey appellant versus Dakshineswar Pandey and others in the court of DC Devghar. It clear from Exhibit B3 that DC Devghar has confirmed the order of NRDC Devghar dated 27/93 of revision miscellaneous case number 93/92/93. Exhibit C is the certified copy of the judgment of title suit number 41/65 dated 29/6/1968 in the court of third additional subordinate Judge Devghar. It appears from the pleasure of Exhibit C that Hori Pandey and Bechu Pandey were not full brothers, not even relation. R11 of Exhibit C. This goes to falsify the pleading of the plaintiff that Hori Pandey and Bechu Pandey are full brothers. It is further clear from the para 33 of the Exhibit C. The learned subject Devghar held that Bechu Bhuka Devi, who alone was entitled to the suit lands till her death, and after her death, Kali Pandey, Dakshineswar Pandey, defendant number 1 is alone entitled to the suit lands to which the plaintiff or other defendants have no title. A certain of the plaintiff appellant in the plaint that Bageshwar Pandey and his sons were in exclusive possession of the suit property of Bhuka Devi is false and baseless. Exhibit D, CC of certified copy of decree sheet of title suit number 41/1965. It appears from Exhibit D that Maheshwar Pandey and Bageshwar Pandey, plaintiff respondent, were defendant number 6 and 7 respectively. Exhibit C, Parcha of Jamabandi number
Exhibit E.
Exhibit E, the Parcha of Jamabandi number 30 of Moja Manikpur issued in the name of Bhuka Devi, wife of Kenu Pandey. Exhibit F, Parcha of Jamabandi number 11 of Moja Manikpur issued in the name of Babulal Pandey, son of Kenu Pandey. Exhibit F shows that Babulal Pandey was son of Kenu Pandey. Exhibit G, substituted photo state copy of Parcha of Jamabandi number 11, Moja Manipur issued in the name of Chowa Pandey. The learned counsel appearing for the appellant defendant in course of his argument contended that finding of the learned court below are against the material on record and completely ignored the law of fact. Both further argued that there is no evidence on the record to show that Peru Pandey was father of Hori and Bechu Pandey. It is clear mentioned in para 11 of the Exhibit C judgment of 41/65 that Hori Pandey and Bechu Pandey were not full brothers, not even relation. Therefore, genealogical table given by the plaintiff respondent showing Peru Pandey as father of Hori Pandey and Bechu Pandey is false. It further contended that Hori Pandey was the son of Gaur Pandey and Bechu Pandey was son of Peru Pandey. Therefore, Bechu Pandey had no any concern with the family of Hori Pandey as they belong to different branches. Bhuka Devi was absolute owner of the suit property, Jamabandi number 67, and it was admitted that Bhuka Devi recorded in Gandanger's settlement Exhibit E. The learned court has also held in Exhibit C that Bhuka Devi was in possession of the suit land till her death. The claim of the plaintiff appellant that on the request of Mukha Devi, Bhuvneshwar Pandey came in Moja Manipur and started living with her, came in possession of the soup land and used maintained Mukha Devi on the point of possession except plaintiff respondent. No other witness has examined to speak that Bhuvneshwar Pandey or Bageshwar Pandey is in possession of the soup land. The learned counsel further contended that the case of the plaintiff respondent is mainly based on the family settlement exhibit C. He contended that Bhuvneshwar Pandey, Bageshwar Pandey and Maheshwar Pandey are no concerned with the family of Kinu Pandey or Bhukha Devi. They are different branches and totally stranger in the family of Bhukha Devi. It has been held by the learned subject Devgar entitled suit number 4165, Exhibit C, that Hari Pandey and Beju Pandey were not full brothers. Hari Pandey was son of Gaur Pandey and Beju Pandey was son of Peru Pandey. In view of the first findings, title suit number 4165, it is clear that Bageshwar Pandey respondent and Maheshwar Pandey belongs to branches of Peru Pandey, so they are stranger to the family of Bhukha Devi. Bageshwar Pandey has not filed any sheet of paper to prove that he belongs to family of Bhukha Devi. He further urged that there was no family arrangement during the lifetime of Bhukha Devi. Bhukha Devi died in the year 1964. And family arrangement settlement exhibit C was pronounced on 5/80 with a view to grab the property of Bhukha Devi. Family settlement exhibit C is concocted and thought that Bhuvneshwar Pandey appellant defendant was a student and his signature was obtained in exhibit C under influence by Bageshwar Pandey and Maheshwar Pandey. The suit property being non-transferable land, the same could not be transferred by the plaintiff on the basis of family settlement. Exhibit C, as the plaintiff respondent is complete stranger to the family of Kenu Pandey and Bhukha Devi, family settlement is hit by section 20 and 69 of the SPT Act.
Plaintiff is बोलना बच्चू भीखू शिवलाल भुवनेश्वर and Bageshwar. Who is Bageshwar?
Bageshwar is a son of Bhuvneshwar. The Bhuvneshwar was two sons
Okay,
of
back to
Maheshwar,
sons.
Maheshwar and Bageshwar.
Maheshwar and Bageshwar. Essay number 588 of 2004. This appeal has been filed against the judgment dated 9/9/2004 within bracket decree signed on 22/9/2004 passed by the additional district judge fast track court number 3 Devgar whereby title appeal number 23 of 2001 has been allowed. The trial court judgment has been passed. The trial court judgment is dated 8/10/2001, within bracket decree signed on 27/11/2001, bracket close, passed by learned Subjudge Romantri Devkar in title suit number 284 of 1997. The title suit was decreed the defendant number 1 to 3, who were the contesting defendants, were the applicant before the first appellate court. The first appellate court has reversed the judgment and decree of the trial court, and consequently the plaintiffs are the applicant before this court. The suit was filed by Bhageshwar Pandey, son of Bhuvaneshwar Pandey, and Nareshwar Pandey, Manoranjan Pandey, Dhilranjan Pandey, Prafull Pandey, and Sajjan Pandey, all sons of Bhageshwar Pandey. And the defendants were Dakshineshwar Pandey, the adopted son of
Bhuka
Devi, wife of Kimu Pandey, and defendant number 2 and 3 were sons of Dakshineshwar Pandey. The pro forma respondents / defendant second party. Pro forma defendants only many. The pro forma defendants were Maheshwar Pandey, were sons of Maheshwar Pandey and Maheshwar Pandey, son of Bhuvaneshwar Pandey, and his two sons. The suit was filed for the following relief: plain settlement. The Schedule A property was Jamabandi number 67 of village Manikpur,
Jassi.
total area 21.39 acres, and Schedule B किसका था? वो भी मानिकपुर का था, उसमें नहीं लिखा।
Schedule A property, Jharkhand number 67, Manikpur,
Yes. Schedule
and
B.
Schedule B is property in Tibet. Schedule B में लिखा हुआ नहीं, total 13.93 acres.
Schedule B का जिक्र कहाँ पर?
Family arrangement में लिखा हुआ है.
Schedule B property क्या है? What is schedule?
Jesse D.
Where is it mentioned?
Notice the type could be of the family arrangement in my kindly see page 7 also.
Page 7.
Page 7 of the exhibit 5 also.
No, we are just looking at the plate. Where is it mentioned? The entire story begins with the plate only. This is the basic document. Okay. Schedule B property is said to have been allocated to the share of the plaintiff Bageshwar Pandey and defendant Maheshwar Pandey out of the suit property.
Defendant number 4. Maheshwar Pandey.
Yes. Maheshwar Pandey, defendant number 4, out of the suit property by virtue of registered families arrangement,
Family arrangement deed.
family arrangement dated 5/12/1980, and accordingly the plaintiff claimed half share of Schedule A property
And B.
and entire Schedule B property. Based on the registered family arrangement dated 5/12/1980. Correct? As per the case of plaintiff, the family tree was given in paragraph 1 of the plate, according to the plaintiff, Pairu Pandey was the common ancestor of Horil Pandey and Baitu Pandey. The branches of Horil Pandey were as follows. Choba Pandey was the son of Horil Pandey, who had two sons, namely Ram Pandey, who died issueless, Shriram Pandey, who died issueless, and Durga Pandey. Durga Pandey had one son, namely Trinu Pandey, who was married to Bukka Devi, and Bukka Devi was the recorded tenant of the property of Schedule A property.
A and B.
B is a part of Schedule A, of Schedule A property, situated at village Manipur. On the other hand, the descendants of Baitu Pandey were as follows. Bipu Pandey was son of Baitu Pandey. Shivlal Pandey was son of Bipu Pandey. And Bhuvneshwar Pandey was son of Shivlal Pandey. Bhuvneshwar Pandey had two sons, namely Maheshwar Pandey, within bracket different number 4, and Bageshwar Pandey. Further, Maheshwar Pandey had three sons, Nageshwar Pandey, Dakshineshwar Pandey, and Anirudh Pandey. Dakshineshwar Pandey and they had two sons, Pintu Pandey and Chintu Pandey. All the descendants of Maheshwar Pandey, including Maheshwar Pandey, were made defendants in the suit. On the other hand, Bageshwar Pandey, son of Bhuvneshwar Pandey, had three sons, namely Nareshwar Pandey, Manoranjan Pandey, Devranjan Pandey, and Prafullu Pandey, and also Sachin Pandey. Prafullu Pandey, who were all sons of Bageshwar Pandey, and Nareshwar Pandey had two sons, namely Sachin Pandey and Santosh Pandey. Correct? The descendants of Bageshwar Pandey descendants of Bhuvneshwar Pandey. So, descendants of Bageshwar Pandey and were the plaintiffs, including Bageshwar Pandey. Himself. it is not in dispute that the it was a case of the plaintiff that Kimu Pandey died issueless, leaving behind his widow Bhukka Devi, who had no issue. And ultimately, in order to maintain her,
There one issue, Vinay Pandey.
वो मर गया ना पहले,
मर गया।
उसका तो कोई relevance नहीं. And for the welfare of herself, Bhuvneshwar Pandey, father of the plaintiff, within bracket Bageshwar Pandey, came down to village Manipur and settled there with Bhukka Devi and started cultivating her land. According to the plaintiff, since Bhukka Devi and her husband Kimu Pandey died issueless, therefore Bhuvneshwar Pandey was the next reversioner of late Kimu Pandey. And he resided with Bhukka Devi as he was likely to inherit the suit property upon demise of Bhukka Devi. After the death of Bhukka Devi, Bhuvneshwar Pandey came in exclusive management and possession of the property of Bhukka Devi mentioned in Schedule A of the plate. During the lifetime of Bhuvneshwar Pandey, who was in exclusive possession of the suit property, he paid rent in his name and his name was also entered, and even in the circle office, the suit property stood recorded in the name of Bhukka Devi and Bhuvneshwar Pandey. And Bhuvneshwar Pandey continued in possession Bhukka Devi died in the year 1965 and Bhuvneshwar Pandey died in the year 1960. Bhuvneshwar Pandey died prior to Bhukka Devi, as per the plate. And on demise of Bhuvneshwar Pandey, his sons, Bageshwar Pandey and Maheshwar Pandey, continued in exclusive possession of the suit property. And consequently the plaintiffs claimed valid right title and interest over the suit property along with defendant Maheshwar Pandey and his team. It was a further case of the plaintiff that upon coming into force of Hindu Succession Act 1986, Bageshwar Pandey and Maheshwar Pandey were alarmed and under Miss advice and in order to get their sons or grandsons eligible for adoption. अभी कुछ नहीं नहीं हो सकता, आप इस तरह से नहीं कर सकते. Please, I won't permit you. Please don't say. I will not even record your appearance.
I am supporters of.
कोई मर गया इसमें? नहीं ना? In order to safeguard their title over the suit property, which stood recorded in the name of Bhuka Devi, decided to give Dakshineshwar Pandey, whose biological father is Maheshwar Pandey, in adoption to Bhuka Devi. However, they denied that that's all. However, they denied that. Maheshwar Pandey and his wife gave their son Dakshineshwar Pandey in adoption to Bhuka Devi on 27/1964, and a deed of adoption was also executed and registered by adoption deed number 200 dated 22/9/1964. The state adoption deed was challenged by Gotia of the parties in title suit number 41 of 1965 /10 of title suit number 41 of 1965 /10 of 1965, and the suit was dismissed by judgment and decree dated 29/6/1968, and consequently the adoption of defendant Dakshineshwar Pandey was upheld. It was asserted that the plaintiff Bageshwar Pandey and his brother defendant Maheshwar Pandey continued in possession of the suit property. Pro forma defendant. It was further case that the two brothers, namely Bageshwar Pandey and Maheshwar Pandey, were joint and had cordial relationship. the plaintiff and Bageshwar, the plaintiff, Bageshwar Pandey and Maheshwar Pandey decided to enter into a family arrangement and Maheshwar Pandey insisted to involve the defendant Dakshineshwar Pandey as well in the family arrangement, to which Bageshwar agreed, and a family arrangement was entered into amongst Dakshineshwar Pandey as first party and Maheshwar Pandey and Bageshwar Pandey as second party. And in the family arrangement, the defendant number 1 got 6 acres 4 decimal of land out of the suit property, and Maheshwar Pandey and Bageshwar Pandey jointly got 13 acres 93 decimal of land out of suit property. And under the same family arrangement, the house bearing plot number 594 and the tank plot number 548 were kept in joint amongst them. It is the property which has been allocated to Maheshwar Pandey and Bageshwar Pandey by way of family arrangement, total 13 acres 93 decimal of land, which is the Schedule B property of the present case. The family arrangement was also registered as deed of family settlement number 3328 of 1980, registered in the office of sub-registrar. And as for the family settlement, the parties started to make payment of rent to the state. It was a case of the plaintiff that the family settlement dated 5/12/1980 was fully implemented and acted upon by the defendant Dakshineshwar Pandey in collusion with his father Maheshwar Pandey. The family settlement was fully implemented and acted upon. However, the defendant Dakshineshwar Pandey, in collusion with his father Maheshwar Pandey, developed dishonest intention to claim the entire suit property. And consequently, certain proceedings were initiated, including one revision miscellaneous case number 13 of 1992-93, and by order dated 27/1/1993. In the same proceeding, there was a direction passed to remove the name of Bhubaneswar Pandey from Register 2. The appeal against such order was also dismissed by the order dated 22/4/1993. The plaintiff also claimed adverse possession with respect to the property which was originally recorded in the name of Kadu. And it was also asserted that the defendant number 1, Dakshineshwar Pandey, had nothing to inherit by virtue of the adoption deed, as the suit property, as Bhubaneswar Pandey, by virtue of long possession, had perfected the title over the property. It was asserted that the family settlement dated 5/12/1980 is binding upon the parties, and therefore the plaintiffs and therefore the suit was fit to be decreed in view of the family settlement dated 5/12/19.
line name हमारे
As a line name है तो उसको हम नहीं acknowledge कर सकते.
या इम्पोर्टेंट है
ऐसे नहीं, हम इस तरह से नहीं कर सकते. तो जजमेंट आप लेके नहीं आए, इसको हम क्या ही करें. The suit was contested by the defendant number 1 to 3. Clearly denied the genealogy in as much as they stated that Hilal Pandey and Mrityu Pandey, in as much as they stated that Baidu Pandey was not the common ancestor and Harilal Pandey and Mrityu Pandey were not the descendants from the common ancestor, and they are of different branches. It was also asserted that the genealogical table of Bachchu Pandey and Horil Pandey was given and confirmed in title suit number 41 of 1965, in which and therefore it could not be challenged. It was asserted that ancestors of Bhuka Devi had no concern with the property of Navadi. Similarly, the ancestors of plaintiffs had no concern with the property of Manipur at Jasidi. Since Haridhan Pandey and Metru Pandey were from different branches, there was no question of partition of property between Haridhan Pandey and Metru Pandey. It was asserted that Devi was wife of Pinu Pandey and was the recorded tenant. Pinu Pandey died long back and left behind one son, Babulal Pandey, and widow Miku Pandey. Babulal Pandey was recorded as the sole owner of Jamabandi number 30, and after death of Babulal Pandey, his mother was his legal heir and successor, and she came in exclusive possession of the Sood property at Manipur. However, she never requested Bhuvneshwar Pandey, father of plaintiff number 1, to help her in cultivating and manage other affairs of the property. It was false to say that Bhuvneshwar Pandey started possessing and cultivating the Sood properties. She died in the year. It was also false to say that Bhuvneshwar Pandey was reversioner of Pinu Pandey. Bhuka Devi died in the year 1965, leaving behind. It was asserted that Bhuka Devi died in the year 1965, leaving behind her adopted son Dakshineshwar Pandey, the defendant number 1, who became the absolute owner of the Sood property after death of Bhuka Devi. It was false to say that Bageshwar Pandey and Maheshwar Pandey jointly possessed the Sood property. It was also asserted that when the defendant came to know about the mutation of entry in the name of Bhuvneshwar Pandey in Register 2, a petition was filed for deletion of his name, which was allowed in Division Miscellaneous Case number 13 of 1992-1993, and the name of Bhuvneshwar Pandey was removed, against which the appeal was also dismissed. And Bhuvneshwar Pandey never possessed the property, rather Bhuka Devi was the exclusive owner and possessed the entire property. It was the case that Bhuvneshwar Pandey and Bageshwar Pandey or Bageshwar were not the family members of Bhuka Devi. It was asserted that the family arrangement dated 5/12/1918 with Dakshineshwar Pandey and partition of the land as per family arrangement in the giving share to Dakshineshwar Pandey was illegal void and was asserted to be in contravention of Section 20 of the SPT Act, and it was asserted that the family arrangement did not confer any right, title and interest on the plaintiffs and other defendants. It was false to allege that the schedule B of the land and it was also asserted that on the basis of family arrangement, the plaintiffs could not claim any right, title, interest over the field card. The following issues were framed by the London Trial Court. The London Trial Court took up issue number 3, 4, 6, 7, and 8 together by paragraph 6 onwards, and after considering the materials came to a finding the after discussing the oral evidences, the documentary evidences were discussed, and ultimately came to the finding that Bageshwar Pandey and ultimately decided the proceed issues in favor of the plaintiff and against the defendant. The trial court took up issue number 3, 4, 6, 7 and 8 together and decided the same in favor of the plaintiff and against the defendant. So far as issue number 5 is concerned, it was held that the adoption deed is of the year 1964 and the family settlement is of the year is dated 5/12/1980. And held that the family settlement was and held that the adoption deed was made under wrong advice as in the family settlement of 1980 there is signature of Dakshineshwar Pandey along with other parties to the family settlement. The court was of the view that under such circumstances the family settlement it could not be proper to hold that the family settlement was not in accordance with law. With respect to the issue number 3, it was held that the father of the plaintiff, namely Bhuvneshwar Pandey, has been residing in Manipur with Bhuka Devi since prior to 1949 and had acquired right title and interest over the property. With respect to issue number 1, 2 and 10, the learned trial court held that the suit was maintainable and plaintiff was entitled to the decree. The court recorded that the registered family settlement dated 5/2/1980 that on the basis of registered family settlement dated 5/2/1980 fresh proceedings be initiated to enter the name of the plaintiff in the register too. The learned court recorded that the plaintiff the learned court decreed the suit as per the relief claim. So far as the learned first appellate court is concerned, no separate point for determination were framed, but all the issues were taken up as were framed by the learned trial court. The learned first appellate court recorded findings with respect to issue number 3, 4, 6, 7, 8 from paragraph 6 onwards, and discuss the documentary evidences on record in paragraph 12 as under. The learned court recorded that the learned first appellate court recorded that Exhibit C was the certified copy of the judgment passed in title suit number 41 of 1965 slash 10 of 1968 dated 29/6/1968, and it appeared from Exhibit C that Oril Pandey and Bettu Pandey were not full brothers and were not even in relation, and held that this falsified the pleading of the plaintiff that Oril Pandey and Bettu Pandey were full brothers. The learned court also recorded that the assertion of the plaintiff in the claim that Bhuvneshwar Pandey and his son were in exclusive possession of the suit property of Duka Devi was also false and baseless. The learned court also recorded that Bettu Pandey had no concern with the family of Oril Pandey. The learned court recorded that all the documents indicated that Bageshwar Pandey was residing in village. The learned court ultimately was of the view that the learned trial court erred in deciding issue number 3, 4, 6, 7, and 8 in favor of the plaintiff, and was of the view that the plaintiff had failed to prove his right, title, and interest over the suit property. While deciding issue number 5, the court held that as under paragraph 14. Issue number 9 is paragraph 15 and issue number 1, 2 and 10 in paragraph 16. ये छोटा छोटा है इसको करना है. So 14, 15 and 16. The first appellate court ultimately set aside the judgment passed by the trial court. After holding that Horil Pandey and Bachchu Pandey had no connection whatsoever. There is also a clear finding that Dakshineshwar Pandey was the biological father of Maheshwar Pandey, and Maheshwar Pandey fell in was a descendant of Bachchu Pandey, and Dakshineshwar Pandey was given in adoption to Bhupi Devi, and Bhupi Devi fell as wife of descendant in the family of Horil Pandey. The learned counsel for the appellant, while referring to the substantial question of law, has submitted that the family settlement entered in the year 1980 was a registered document, and at no point of time the same was challenged, and accordingly the family settlement was binding on the parties. Then, yes, relied upon the judgment reported in SCC concerns. AIR 2010 AIR SC 211.
Relevant paragraph 19. A registered document being the part or body which is required to be challenged.
Just a moment. Abdul Rahim versus Sheikh Abdul Jabbar. And as referred to paragraph 19 thereof. To submit that, on the one hand, to submit that
my submission is that a registered document being void or voidable, it is required to be challenged within 3 years from the date of knowledge.
To submit that a registered document being void or voidable has to be necessarily challenged within 3 years from the date of knowledge.
Admittedly, the defendants did not challenge.
Admittedly, the defendant did not challenge the registered family arrangement of the year 1980 by filing any separate suit or any counterclaim in the suit.
Meaning they are the
Although they had questioned the family arrangement in the written statement.
Meaning they are the accepted the registered family.
Accepted that they have challenged it in the written statement.
Yes.
The learned counsel submits that unless the family arrangement of the year 1980 is set aside, the same continues to be binding, and as of now, challenge to family settlement has become barred by litigation. He submits that under such circumstances, the decision, the suit based on family settlement was maintainable, and therefore the plaintiffs had rightly filed the suit for declaration of half share of the
declaration of right title interest including the half share of the suit.
For declaration of right title and interest including the half share of the suit property. That is the entire share of Schedule B property.
Schedule B.
Schedule B का पूरा,
Yes.
which was allocated to them in the family
Settlement.
of the year 1980.
80.
यही है आपका. The learned counsel for the respondents, on the other hand, while opposing the pledge, has submitted that the entire case of the plaintiff was demolished in view of the fact that there was already a finding in the earlier suit of the year 1965 that Horil Pandey had nothing to do with Battu Pandey, and they were not related to each other. He has also submitted that once the deed of adoption of Bukku Devi, whereby she adopted Dakshineshwar Pandey, biological son of Maheshwar Pandey, was held to be valid in the earlier titles. And therefore, Dakshineshwar Pandey ceased to have any relationship with his biological father, namely Maheshwar Pandey. He has also submitted that Dakshineshwar Pandey was, by virtue of adoption, Dakshineshwar Pandey became the descendant of Horil Pandey as husband of Bukku Devi, namely Kinu Pandey, was the descendant of Horil Pandey. The learned counsel has submitted that the learned first appellate court has rightly passed the impugned judgment. Registration, इसका आपको क्या बोलना है? Registered document के बारे में? Do you have to say anything with respect to the registered document?
I am respondent 10, legal error of the respondent 10, my lord. I am only supported the case of the appellant because I have accepted the family settlement because I am not never denied. That is
You are the
respondent number 10.
Respondent number 10.
Yes, Nageshwar Pandey.
Nageshwar Pandey.
Yes, the legal error of the Nageshwar Pandey. So I am supported the case of appellant. There was a family settlement. I never denied that.
Nageshwar Pandey belongs to which branch? Horil Pandey or Battu Pandey?
There was a
Nageshwar Pandey belongs to which branch? Horil Pandey or Battu Pandey? Certainly Battu Pandey. The respondent number 10 in the present case submits that he is the descendant of Battu Pandey. Correct? And accordingly supports the case of the appellant who are the plaintiffs.
He accepted.
And they are also descendants of Battu Pandey. He submits that Nageshwar Pandey has also accepted the family settlement, and Nageshwar Pandey was second party in the family settlement along with Maheshwar Pandey. आप ये registered deed के बारे में आपको
Registered
बोलना
deed के बारे में कहना है कि the family settlement, page 21 of the appellate judgment. Family settlement exhibit C is the concocted and forged.
आपने कभी चैलेंज नहीं किया इसलिए हम पूछ रहे हैं.
तो उसी कारण his signature was obtained on exhibit C under influence by Maheshwar Pandey and Maheshwar Pandey, the suit property being non-transferable, Raiti land. The same could not be transferred by the plaintiff on the basis of family settlement. Exhibit C is the plaintiff respondent.
Just a moment. The learned counsel has submitted that since Horil Pandey and Battu Pandey had no biological relationship with each other, therefore the family settlement,
Hit by section 20.
just a moment, family settlement amounts to transfer of property which belong to the branch of Horil Pandey to Battu Pandey. and such transfer of property is hit by the provision of section 20 and 69 of Santhal Pargana Tenancy Act, as the properties in Santhal Pargana are non-transferable in nature. He has submitted that since the properties are non-transferable in Santhal Pargana, the design to transfer the property by virtue of the registered family settlement of the year 1980 makes the family settlement void ab initio and against the statutory provisions of Santhal Pargana Tenancy Act. The Learned Council has submitted that the Learned First Appellate Court has rightly taken note of section 20 and section 69 of Santhal Pargana Tenancy Act to reject the plea of the plaintiffs based on the registered family settlement dated 5/12/1980. He has also submitted that once the registered deed is void ab initio and against the statute, the same can be taken care of by the learned courts, even if they are not specifically challenged. इससे ज़्यादा तो आप कुछ नहीं बोल पाएंगे, ठीक?
इसमें अगर लॉजिक परमिट करते हैं,
बताइए।
so far is section 20 and 69 of the SPT Act lordship. It is not a transfer of land. It is a partition between the family members. Therefore, it is not barred by section 20 and 69 of the
Learned Council for the appellant has
Because they
submitted
are
that.
also residing in same
Just
place.
a moment, we hold on. The Learned Council for the appellants and respondent number 10 have submitted that section 20 and section 69 of Santhal Pargana Tenancy Act does not apply to the facts and circumstances of this case, in as much as the registered deed of 1980 is not a transfer of property, but it is a family arrangement within the family members, and all are the co-sharers of the property.
Yes.
He submits that in such circumstances, the argument of the contesting respondent is misplaced. Pratap?
Okay, because appellate court, my lord, first appellate court doesn't make any substantial question regarding that especially. कि वो कभी substantial question of fact बनाए ही नहीं कि उसका ही नहीं हो सकता है. First appellate court. They have reversed the judgment of the central judge. Before reversing any judgment, there must be substantial question to hit that section.
Points to determination.
That should be also. That is a principle.
That is not the substantial question of law involved in this case. जितना है उसके बाहर तो हम जा नहीं सकते हैं. I have to decide the case. I have to decide the case within the four corners of the substantial.
Yes. Only by submission, my lord.
ऐसे कैसे आपका submission कुछ भी लिखाएंगे? Beyond what
Beyond
it is.
that भी statute कहता है कि उसका सबसे reversal में must be determination में. That is a settlement.
That's all. Arguments concluded. Post for may order is reserved. Post for judgment on (29th of October) or any other day as may be notified by the court, whichever is earlier. बीच में हो जाएगा तो हम कर देंगे. Later 29 को तो आएगा. बहुत ही टेक्नोलॉजी बहुत
दो बजे रात से हम पढ़ रहे हैं. जियोलॉजी समझ में नहीं आ रहा था.
अब समझ में आएगा ना?
एकदम किसी को असिस्ट कर पाया था, मैं मुश्किल था. एक एक चीज एक एक के बाद
सिरे से पढ़ने से चीजें क्लियर हो जाती हैं।
सीक्वेंस में जो जाने से आता सीक्वेंस यदि टूटता है तो फिर कोरिलेट नहीं हो पाता सेकंड अपील में देखें
प्लेन एंड रिटन स्टेटमेंट बिना देखे जो सेकंड अपील डिसाइड हम कर देंगे ना वो गलत होता है।
एकदम सीक्वेंस
सारा कहानी प्लेन रिटन स्टेटमेंट में रहता है।
बहुत सा फैक्ट जो है जजमेंट में नहीं आ पाता है
नहीं ऐसा कोई नया फैक्ट का बात नहीं है, चीजें क्लियर नहीं होती।
सीक्वेंस में कौन
कौन
पाता है
पार्टी है, कहाँ इनोलॉजी कैसे मूव कर रहा है,
इमेजिन नहीं हो पाता पूरा कोहेरेंट
जैसे कि प्लेन टू डब्ल्यूएस में सेक्शन 2069 के बाद
सूट कब का है? पूरा दिन का मेहनत से हमको लगता है एक तो कम से कम पुराना केस कुछ का कुछ कर दिए। 95 का सूट है,
93 का है
93
सूट नंबर 280 पहले 37 93 पड़ा था, बाद में 284 ऑफ 97।
मेरा तो इस प्रोफेशन में जन्म भी नहीं हुआ था 96।
हम लोग भी नहीं
आई जॉइंड इन 95। चलिए ये ना 29 वो चले, ये दोनों जो सेक्शन है ना एसपीटी का सेक्शन 29 और वो दोनों कोड का
For hearing item 26, second 2374 of 2016.
छुट्टी को दो दिन पढ़े नहीं पढ़ पाए, एक लाइन भी नहीं पढ़ पाए। दुर्गा पूजा में छुट्टी में पढ़ा
नौकराना ला
नहीं नौकराना so far the nokrana land I have not gone through, but so far the law politics has said in nokrana landlordship CT Act will not apply. 2004 GLGR
नहीं सीएनटी का तो बात ही नहीं, इससे सीएनटी का इशू ही नहीं।
अच्छा क्योंकि हम पढ़े नहीं इसलिए कोई जानकारी नहीं।
नौकराना लैंड इज नॉट वेरिफिकेबल। एक केस में डिसाइड किए हैं मिस्टर शर्मा
देख लेंगे
यही तो सब्सटेंशियल क्वेश्चन होगा पहला।
एक लाइन नहीं कहते
आपके पक्ष में बात कर रहे हैं, आपको नहीं चाहिए जजमेंट तो कोई बात
नहीं एक
नहीं,
लाइन
कब चाहिए बताइए।
छुट्टी के बाद रख दी है
वो आप देखिए।
हम लोग छुट्टी में हम एक डेट फिक्स कर दिया जाए छुट्टी के बाद फर्स्ट डे ही रख दिया जाए रीओपनिंग।
रिस्पोंडेंट कौन? Who is appearing for respondent?
Mr. Anupam Anand and Mr. Mukesh Kumar.
कई बार इसमें कॉस्ट कर करके आपका हो गया
जी इसे देखा जाए जो हर सेकंड अपील में सबको कॉस्ट लगता है, हर सेकंड अपील में अगर देखा जाए सब किसी को 1000 किसी को 2000 किसी को
कॉस्ट सब में
सब में आप देखिएगा लॉटरी
तो क्यों नहीं लोग आप लोग किए समय पर?
कुछ कारण से वो पर्सनल
वही सबको पर्सनल डिफिकल्ट, हाँ सबको पर्सनल डिफिकल्ट, पूरा बार को पर्सनल डिफिकल्टी हो गया।
नौ नंबर कोर्ट में कोर्स दे के टाइम दिया तो वहाँ का प्रिंसिपल है कि आप कोर्स दीजिए, आप 8 वीक तक का टाइम दीजिए 9 नंबर कोर्ट। अच्छा समय हम लोग जमा करते हैं
यहाँ पे एक जीरो ऐड कर देते हैं,
तो हम लोग सेकंड
एक का 10,000 2,000 का 20,000
सेकंड भी नहीं
सारा मेरे लिए छोड़ नहीं
नहीं लोग इतना डिस्पोजल कर रहे हैं कि हम लोग दशहरा बन रहा है, दशहरा दिवाली छठ पूजा बन गया हम लोग बिल्कुल बिल्कुल
काउंसिल लोग खुश रहे हैं, लिटिगेशन तो चलते
पूरा
रहेगा।
रात खुश लौट
नहीं हम नहीं सब मतलब नहीं,
हम लोग तो खुश हैं
आप लोग अपने कमाइए खुश रहिए,
बिल्कुल।
केस करिए,
बिल्कुल
सिविल लिटिगेशन में अपने जूनियर लोग को डेवलप करिए।
जी हम लोग तो कर रहे हैं, हम लोग भी बता रहे हैं तो मेहनत कीजिए
क्योंकि नेक्स्ट जनरेशन नहीं डेवलप हो रहा।
हाँ नहीं हो पा रहा
Essay number 374 of 2016. Counsel for the applicant is present. Nobody appears on behalf of the respondents. Counsel for the appellant has submitted that he could not go through the file as he was going to the records of another case which he has argued today. He seeks adjournment. कब करते बताइए?
रीओपनिंग में फर्स्ट जो टॉक्सिक में हम लोग के लिए अच्छा है।
अब आपके किस्मत में कौन सा बेंच है देख लीजिए। Post this case on 8th of October. अगला दिन टाइम मत मांगिएगा।
नहीं उसके बाद हम टाइम नहीं मांगेंगे।
एक सेकंड। A soft copy of this order be forwarded to the counsel for the respondent to ensure appearance on the next date.
Item 27, second to 379 of 2016.
नहीं ऐसे नहीं चलेगा ना, ऐसे नहीं हो सकता।
दुनिया में जिसको अगला सप्ताह
नहीं अगला सप्ताह से क्या ऐसा नहीं हो सकता। It just can't be like this. Where is it? आपका जूनियर क्या करता है? एक बार डीएमटी हो चुका है, एक बार क्या कई बार हो चुका है।
डे आफ्टर टुमारो रख दीजिए लॉर्डशिप्स। डे आफ्टर
फाइल खोलिए, ओपन द फाइल।
डे आफ्टर टुमारो रख दीजिए।
फाइल भी नहीं लेकर
फाइल भी छोटी है। डे आफ्टर टुमारो रख दीजिए।
एडवोकेट क्लर्क एसोसिएशन में कॉस्ट जमा कराना बंद कर देंगे। They are not doing their work. आपका फाइल छोड़ के क्यों आपके एसोसिएशन को पैसा दें हम लोग कॉस्ट का? ऐसे नहीं करने का है, कॉस्ट जमा करवाना बंद कर देंगे हम आपके एसोसिएशन। कितना अच्छा क्वेश्चन है।
परसों रख दीजिए इसको हम कर परसों।
अदर साइड कौन?
दूसरे लेके सामने और से।
यही सी।
दूसरे को
Counsel for the appellant is present. Nobody appears on behalf of the respondents. परसों तो नहीं। एक तो amicus बताइए किसका कौन करेगा?
हम लोग देखिए करेंगे। हम लोग देखिए इसका
नहीं respondent की तरफ से।
नहीं लिस्ट वगैरह से बाहर नहीं जाएंगे सामने से।
इसका तो है।
कहीं रिपोर्ट में बस कर रहे हैं।
क्या है? मिस्टर सानी एक तो लिस्ट ऑफ amicus दे दीजिए जब हम आपके एब्सेंस में अपॉइंट कर रहे हैं। अपने जूनियर का ही दे दीजिए। हाँ।
ऊपर में से 14 नंबर में
बताइए क्या है?
देखे तुरंत दौड़ का।
बताइए क्या है?
Now the defendant respondent is the appellant. Now they have asserted the order of the appellate court, whereby the suit for partition brought by the plaintiff respondent has been decreed. I will refer only 2 paragraphs of the trial court judgment.
Substantial question of law तो रेफर करिए नहीं पता।
Substantial question.
The learned counsel for the parties are present. Counsel for the applicant seeks adjournment. The learned counsel for the respondent is also not ready with the proof. The substantial question of law नहीं पता है तो not ready with the proof.
Ready with the brief part.
कैसे? You do not know the substantial
जब
question.
आप शुरू करेंगे ही करेंगे तो हम सुनाएंगे तो 1 मिनट में हम देख लेते हैं
अच्छा ये मत लीजिए। The learned counsel for the respondent is present.
उतना ही था
With the consent of the counsel for the parties, pose this case day after tomorrow. 10:30 बजे।
जी
एक और रखे हैं शायद 10:30 बजे कौन से केस में याद नहीं। थोड़ा वेट करेंगे,
जी सेकंड के दो
एक केस और
जी
देखते हैं दोनों में से कौन सा होगा। अपना जूनियर लोग को सबको रेडी करिए,
जी बहुत देर नहीं लगेगा
इसमें टाइम नहीं लगेगा,
कितना
जूनियर लोग को
देर
रेडी करिए। कोई
हाँ,
आप
मुझे-
करेंगे ना, आप इनके साथ हैं नहीं है, आपके साथ हैं? कुछ नहीं सिखा रहे, उनको रेडी करिए, बताइए कैसे करना है,
जी
ठीक है?
Item 28, second appeal 380 of 2016.
Appellant, please. Appellant come. Respondent is going to be joined by DC और appellant is going to where is the appellant? Nobody appears on behalf of the appellant. Therefore, the respondents.
Yes.
Also for the respondents is present. Repeated adjournments has been given in this case. No request for adjournment, no advance notice seeking adjournment has been submitted. आप कोई बोले थे टाइम नहीं? Counsel for the respondents upon query of this court has also submitted that he has also not been intimated about any adjournment request on behalf of the second appeal is of the year 2016. In order to give one more chance to the counsel for the one more chance to the appellant, the matter is adjourned and is directed to be posted on 8th of October 2025, subject to payment of cost of rupees 10,000. The cost should be deposited in the account book Welfare Association clerk. The receipt regarding payment of cost should be filed before this court latest by 6th of October, failing which this appeal shall stand dismissed without reference to the bench.
In this case, I have only copy of judgments not on the pen drive.
इसका स्कैन कॉपी आप ले लीजिए पेन ड्राइव।
Item 39, second appeal 396 of 2016.
the appellant? Essay number 396 of 2016. Nobody appeals on behalf of the appellant. On behalf of the parties. The case has been adjourned on repeated occasion upon payment of cost. No notice, no advance notice seeking adjournment has been submitted. Back to same order. 10,000 rupees. Same date, same order. The amount has to be एक सेकंड आप किस केस में हैं? किनकी तरफ से? तो बस हम कॉस्ट लगा के एडजर्न किए हैं. If you argue it, I will hear you. Otherwise, I have already imposed cost.
I was in another quotation, and I received the file after no objection.
नहीं कुछ नहीं सुनेंगे.
Tomorrow.
I have already dictated the order. You see, I do not recall my orders like that. I have already dictated the order. I will not hear it.
Lordship, I sincerely apologize.
I have already passed the order. I'll come later.
Your Lordship, kindly consider. Lordship, tomorrow morning, Your Lordship. No. Tomorrow, if it can be possible. Your Lordship, because
where is your file?
Your Lordship, I have only received the memo of appeal and the impugned judgments, Your Lordship.
You did it.
Because
you did it. You start the hearing. You start the hearing. घर में नहीं पढ़े तो अभी पढ़िए. Those people who do not read at home, you have to read it in the court. What is the substantial question of law?
Your Lordship.
ये जो order है 18 to 2019 का order इनको भी कॉपी में. 18 to 2019 का. फाइल खोलेंगे तो शुरू हो जाएगा कल की भी करनी, लेकिन फाइल बिना खोले जाने नहीं देंगे. ठीक है? ट्रायल कोर्ट का जजमेंट करना.
Starts from page 39. The plaintiff, who is the respondent here, has instituted this suit for declaration that defendant is not the adopted son of Puni Gridwari, while registered deed number 179 of 79 is illegal and liable to be cancelled, and for deleting the name of defendant number 4 from column 4 and 11 of the Kharyan of JB number Jamabandi number 20/10 and 22/10 of Moza Purba Birni Circle Sahara Mahara on false ground instituted in the plaintiff. The suit property is described in.
You straight away come to the point for determination. The issue strain.
Your Worship, para 5 of the trial proposal.
Yes.
There were a total of 6 issues that were framed, and perhaps issue number.
What is the finding in connection with issue number 3?
Issue number 3.
That is on the point of determination.
fee have been taken.
Barred by limitation, correct? It has been held to be barred by limitation. The trial court.
Yes,
The appellate court perhaps reverse the judgment. Appeal was allowed.
appeal was
What is on the point of limitation? Issue number 3 again.
considering the finding starts from para 8 of the appeal.
No, you come to para 11.
Para. This issue number 123. That during the course of argument, learned advocate correspondent has again argued that natural father of appellant plaintiff was filed miscellaneous case before settlement of his white miscellaneous case number 2 of 82, and the concerning court decided both adoption rates are genuine, but which is important to say that according to law, without appointing guardian of minor by the court, no lead relief is given in favor of petitioner. It is also admitted that while appellant plaintiff was 4 years old, and as natural father had filed before settlement officer and plaintiff appellant alleged in his claim, she has no knowledge about this case. It is fact that while she was minor, therefore no question arises to knowledge of miscellaneous case that in the year 29/8/2000.
The suit was held to be within limitation.
Yes.
The substantial question of law is not related to limitation.
Worship, I'll have to go through once. One opportunity will be given.
Opportunity appeal, but
The second appeal was admitted by this honorable court on 18th of February.
it is limitation. Limitation is also
More
there.
substantial question.
Where is the respondent?
I'm not sure, perhaps notices.
Who is the respondent?
No name of yours.
They have not appeared.
No name, Worship. No name of yours on behalf of the respondent.
Wakalatnama on behalf of respondent after NOC has been received.
Worship, I have from on behalf of the petitioner. Appellant, sorry. Worship, appellant.
On behalf of the appellant.
Yes.
तो on behalf of respondent लिखा हुआ 18 कौन सा होता है? आपका appellant का वकालतनामा है, respondent का भी वकालतनामा है। Appellant। कैसे लिखते हैं आप वकालतनामा on behalf of the respondent has been received? Appellant is Surendra Prasad.
Yes.
ऐसे कैसे लिखे हैं वकालतनामा on behalf of the डेट भी नहीं लिखा है ना, इतना लिखा तो बात ही करता है। वकालतनामा on behalf of the sole respondent after NOC has been received and kept at flag. लिखा ही हुआ है, who has done it? Sole appellant है, ना कि sole respondent लिखते हैं। कौन इस तरह से करते हैं? This is too much. Who has done this? The counsel for the appellant has commenced his hearing at his request posted. Up time,
Because limitation पे एक issue है, issue number substantial question from issue number 2
तैयार
is
करिए, रात भर पढ़िए, बहस करिए। रेस्पोंडेंट की तरफ से किसी को amicus, अच्छा आपको टाइम दे दूँ, किसको amicus अपॉइंट करेंगे? आपको कितना साल हुआ प्रैक्टिस का? करेंगे? हाँ? नाम बताइए। I'm detailing. In spite of service of notice, nobody has entered the clearance on behalf of the respondents. In order to assist this court, Mr. So-and-so, who is present in the court, has been requested by this court to be an amicus from the side of the respondent. He has readily accepted the request. Accordingly, he is appointed as amicus. Post this case on next Wednesday, yes.
Your Lordship, Wednesday को छोड़ Tuesday या Thursday, because Your Lordship Wednesday को first appeal का एक batch matters लगता है, which several ideas are still pending, so Tuesday or Thursday Your Lordship.
Next Wednesday.
Wednesday. Again first appeal batch matter registered.
क्या होगा? बैच मैटर हो जाए मेरे पास होगा.
हाँ, ये तो उससे थोड़ा ये रहता है. Tuesday Monday
इतना बार्गेन नहीं चलता इसको.
Your Lordship हम पहले करने को बोल रहे हैं.
हाँ?
हम एक दिन पहले ही बोल रहे हैं.
Tuesday. Just a moment. Tuesday. चलिए Tuesday. इसका soft copy. Office is directed to provide soft copy of the entire records of this case to the alleged amicus. Of the memo of appeal and the enclosures. Okay. The alleged court master is directed to retain the records received from the concerned court for perusal of the advocates. Okay. Of the appellant and the amicus.